Charles Russell, Public Defender's Office. Judge, this is going to be Joseph Carroll. Case number is 24 CF 2383. Mr. Carroll's case, I've reached an agreement with the state about depositions. They're scheduled for October the 20th, and we've received some additional discovery from the state that I'm going to have to go out and send to Mr. Carroll. So at this time, we're going to ask for a continuance of the next pretrial conference.
All right, you understand that, Mr. Carroll? Yes?
Yes, sir.
Okay, so he's going to come out and talk to you about some of the new things he's received. Depositions are October 20th. Your next court date's going to be October 29th, so just 9 days later at 9 o'clock.
Judge, my understanding is none of mine are here yet.
Afternoon, Your Honor.
Jake Corley. Oh no, I'm talking to you. Sorry.
That's why we're waiting.
I'm gonna forward.
It seems like we're getting to the PD cases at kind of 1 o'clock almost every
It's a ATF,
pretrial. Do y'all want to
report.
potentially separate it? I know that it was good to have y'all here for some issues, but I'm not suggesting that we do. I'm just asking the question.
Personally,
I'm sorry, go ahead.
personally speaking, I would be for it, Judge. I think granted, I like to get here sometimes in the morning and work a couple last minute things out with the state, but I would do that regardless whether it was set for 1 o'clock or 9 a.m. But I think generally speaking, it'd probably be good to set those cases at 1.
Williams?
Judge, and my jail list overall is down from what it normally is. I've just got one bucket here today. But still, with the jail visits that have to be done to get ready for today, it's going to probably require me to be at the jail somewhat late tonight for people set for tomorrow.
Okay.
So that would give me the morning to see those people.
Okay.
Anybody I hadn't already seen, most everybody for arraignments. And
Why don't you guys talk amongst yourselves as you get an opportunity this afternoon? And we're 2 months away, but I'm setting them all right now, so it might be kind of somewhat too late, but
Yes, sir.
something to consider.
Yes, sir.
But
Certainly
it doesn't change anything for me, obviously. I'm going to be here the whole time, but I just, whatever's more convenient for y'all.
Just on the straw poll, I am, yeah.
Who have you got, Mr.
Um,
Maddox?
I am in favor of it.
Okay.
Your Honor, this is Mr. Stephen Arnett before the court in 25 CF 492. Your Honor, I'm asking for a continuance today. I know the case has gone through a couple cycles. The state and I are a little bit far apart in this one, Your Honor. The state's current offer is 2 years Department of Corrections. Mr. Arnett doesn't score, so we've been talking about that. What I'm going to do is either set depositions, Your Honor, or go over Mr. Arnett's options again, and it'll be, a plea or trial situation or set depositions, one of those. But I would like one more cycle to go over everything with Mr. Arnett and, develop that plan going forward.
All right, you understand that, Mr. Arnett?
Yes, sir.
October 29th, 9 o'clock, but that'll be the third time up at that point, so depots probably need to be done.
If they're going to be
And
set,
around
we'll
that
set 'em.
time.
Yes, Your Honor. I'll come see you, Mr. Arnett. Your Honor, this is Mr. Kyle Bird before the court in 25 CF 1303. It's his first time up, Your Honor. We just had felony plea date on July 31st, if I could have a continuance in the case.
October 29th, 9 o'clock for Mr. Bird. Thank you, sir.
Bogen.
Your Honor, just need to get Mr. Bogen's signature, and we'll have a resolution in the matter. And date it for me today is the 27th of August, 8/27/25. All right, Your Honor, we've reached a resolution. We may approach.
Mr. Bogen has there's a reimbursement request for prisoner transport in his file.
I would ask for that cost to be imposed, Your Honor.
How much is it?
$273.45.
$273.45.
Transport from Leon County Jail.
All right. That's fine, Your Honor.
So is this just 1 year probation, concurrent or consecutive?
Consecutive, Your Honor. It is an agreed-upon plea.
Oh, there it is. It says consecutive.
Yes,
I
Your
just
Honor.
didn't see it. All right. All right, Mr. Bogen, can you raise your right hand?
I'm sorry. The time. Got my right hand up.
All right. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Justin Jerome Bogen, February 27, 2003.
All right, Mr. Bogen, you're here in 23 CF 1482, where you're currently charged with felony criminal mischief and misdemeanor battery. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to plead to a lesser included misdemeanor criminal mischief, which is Florida Statute 806.131B1, and also as charged to the battery case for 11 months, 29 days probation for each count consecutive, which means you'd basically do about 2 years of probation. Do you understand that?
Yeah, I understand. I just it's kind of been a little shaky. Like I've been here 120 days. I talked to my public defender about it, but yeah, I'm cool with it.
Yes, Your Honor.
All right. Did you go over this plea and sentencing agreement with your lawyer?
Yeah,
Did you understand it?
definitely did.
All right. And did you sign it? All right. Are you currently under the influence of any alcohol, drugs, or controlled substances? You currently suffering from any mental health issues?
No, sir.
I asked the same
Yeah,
questions
you
of
just asked that
everybody.
to
Yeah, that's fine. I was gonna tell you I'm depressed. I'm ready to go home, but I'm good. I'm good, man.
That's
We understand
understandable,
that,
Mr.
yeah.
Bogen.
Yes, sir.
All right, but otherwise you understand what's going on here?
Yes, sir.
All right. Anybody force, pressure, or threaten you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Anyone, I'm sorry, you understand by entering a plea, there won't be a trial of any kind, and you're giving up your trial rights, which are on page 2 of that agreement you signed? You understand all that? You understand you're waiving all potential defenses that you may have? I have to hear you.
Yes, sir.
All right, because it's not just me knowing, it's just,
Everybody.
everything has to be recorded.
Yes, sir.
Okay, perfect, thank you. And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yeah, I understand that.
Okay.
You are a U.S. citizen,
Again,
correct?
same questions go to
Would
everybody.
y'all send me
Mr.
to Alcatraz if I wasn't? If I was like,
You are a U.S.
Yeah, I
citizen,
am.
correct? Okay.
I'm not asking the question about citizenship.
He's a
I'm not
citizen,
supposed to
I know,
do
I just
that,
wanted
but
to-
I also don't understand why you're talking about Alcatraz.
no, I was just
Bad
thinking
joke,
about
Your
it.
Honor. We apologize.
No, it wasn't a joke. I was just wondering.
I think you need to take this a little more seriously, Mr. Bogen. All right, and what is your plea to the misdemeanor criminal mischief and the misdemeanor battery?
No contest.
All right, I'm going to accept your no contest plea is freely, voluntarily, knowingly given, adjudicates you guilty of both charges. Each case is going to be 11 months, 29 days probation to be considered consecutive to each other. In count 2, you're going to have to do the batterer's intervention program, which is a 26-week course. No contact with Jatora Cooper unless she provides a sworn statement wanting to contact you to probation. $622 in court costs, $100 cost of defense that's a total of $100. That's 50 and 50, right?
Sorry, Your Honor.
That $100 cost of defense, waive cost of supervision, due to the fact that you've been found to be indigent, Mr. Bogen. I will need you to go talk to probation, then you'll need to be fingerprinted, and you have 30 days to appeal the judgment and sentence.
Yes, sir.
Thank you.
Thank you.
Hey, Ms. Bramble. Your Honor, this is Ms. Bramble in 25 CF 159. The court had previously ordered her to be evaluated by the agency for persons with disabilities. I was wondering about the status of that, Your Honor, so I reached out to Joseph Sanchez. He's my contact over there, Your Honor. I forwarded him everything that he needed to complete the evaluation, and they did say they would expedite it. The reason for the delay, Your Honor, is that they never received the order.
Well, I guess I would suggest, once you receive the order, Mr. Maddox or anyone else, just see if you can personally forward it to them as well to make sure they're
Yes.
getting it.
We will be doing that going forward.
I think I've already explained to everyone ever since we've been dealing with the current situation. My assistant emails a copy of almost every order I sign to the parties in the case. It's hundreds and hundreds of orders.
Yes, Your Honor.
But unfortunately, sometimes it doesn't get to everybody if it doesn't go through the right system. So, all right, so when do they expect to have that done?
I don't know specifically, Your Honor. What I do know is that they assured me that they would expedite it, and they assured me that they had received all materials that they needed. So I sent them the arrest report, the previous competency evaluation, and anything else they requested. And then I received a reply back saying they would expedite it. What that means to them, I'm not sure, but in my experience, they have been, fairly quickly getting
Okay.
these evaluations done.
Well, what do you want to do with it then?
Well, continue it, Your Honor, until, why don't we put it on 9/25 just to make sure it doesn't fall through the cracks, if that's okay?
Okay, what I'm going to do is I'm going to put it for September 25th at 9 o'clock for status on the APD, but then just also set the October 29th pre-trial.
All right, sounds good. Thank you, Your Honor. Your Honor, this is Mr. Brand before the court in 25 CF 848. Your Honor, I'm asking for a continuance in this matter. I'm going to be looking to get depositions set this cycle if possible.
There's no objection.
Any reason why we don't think they can get set before the next pretrial?
Barring a date issue, no, Your Honor, I will look forward
Well, I
to getting
understand, and
set.
that's kind of my point.
Yeah.
I don't know where you guys are pushing out to already, if it's past the next pretrial. I'd like to know that, but. Okay. Well, see what y'all can get set, but
Certainly, Your Honor.
all right, October 29th, 9 o'clock.
Yep. All right, you're good.
All right, thank you, Mr. Brand.
Yes, Mr. Bernett. Your Honor, this is Mr. Anthony Bernett before the court in 25 CF 783. Your Honor, we're going to get depositions set in this case. I also requested additional discovery materials, and the state's looking into that.
All right. Is that Mr. Sheik or Miss Leone?
That's Ms. Leone, Your Honor.
All right.
But we've spoken about it previously.
All right, October 29th at 9 o'clock, Mr. Burnett. As you can hear, they're trying to get through the discovery process, and hopefully that will be done by next time.
And we'll get depositions set, Your Honor. All right, see you, Mr. Burnett. Hey, Mr. Kane. Your Honor, this is Mr. Kenneth Kane before the court in 25 CF 782. We have filed for competency evaluation, Your Honor. We're awaiting that. I emailed Dr. Zeman to see what the status of that was. He expects to have it done in September, Your Honor. Could we put him on 9/25?
All right, let's through September 25th for status on the competency, 10/29 for the
Am I
pretrial
going
conference.
home or?
I wish you were, but no, not at this time. I wish you were, though.
We're going to see you back in a little bit after you've talked to the doctor, Mr. Kane. 9 a.m. Yeah. I don't want to spring that, just to change it and feel like, oh no, we shouldn't have done that. It just seems like every time kind of break.
No, not at this time, sir. Again, I wish they would, okay? Go ahead and go back.
Oh, the 9/25 date. Yes, 9 o'clock. Unless you went for pretrial date.
Your Honor, at this time, I'd ask for a continuance in this case.
Who's this?
This is Miss Winona Carpenter, Your Honor, 25 CF 727. The state has offered Miss Carpenter an 1129 offer. She currently scores 4 years. I've conveyed that to her multiple times. She's still thinking it over, Your Honor. And since that's the situation, I'm going to set depositions in her case and get ready for trial, Your Honor.
All right, Ms. Carpenter, we'll see you back October 29th, 9 o'clock. It sounds like a lot of depositions that get set.
No. Your Honor, this is Mr. Rocky Carter before the court in 25 CF 263. We've reached a resolution, if I may approach.
Mr. Carter, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes, sir. All right, can you state your full name and date of birth, please?
10-5-59,
And your name, please?
Rocky Lane Carter.
All right, Mr. Carter, you're here in 25 CF 263, where you're currently charged with felony battery, third-degree felony, and punished by up to 5 years in state prison, as well as assault upon a person above the age of 65, which is a first-degree misdemeanor, punished by up to a year in a county jail. Do you understand that? You understand that's what you're charged with?
No, sir, I didn't understand.
Okay.
You understand that's your current charges, but there's an agreement for something different, right?
Yes, sir, the agreement's totally different, yes, sir.
Okay, well, and that's why I'm just making sure you understand what you're currently charged with, and then I'll go through what the agreement between you and the state is.
Okay, I'm doing the best I can to hear you.
Okay, we have a,
No, I'm okay, I can hear you.
You sure?
Yeah.
all right, well, I'm doing my best, but.
Yeah, you're doing great, he'll help me out.
Okay, well, I can't have him basically
No.
translating for you. All right, so I've been given a plea and sentencing agreement, Mr. Carter, that calls for you to plead to a lesser-included misdemeanor battery in count 1, 8 months county jail with credit for time served, adjudication of guilt, $622 in court costs, $100 cost of defense. I'll give you 90 days from the date of your release to either pay that or set up a payment plan with the clerk's office. Count 2 would also be an adjudication of guilt, 8 months in the county jail, credit for time served. That time would be concurrent between the two, which means you're doing a total of 8 months for both. Do you understand that?
No, what's that mean by that?
8 months total.
Yes, that's from the date of the arrest.
Correct.
Yeah.
All right,
Yes.
You understand this?
Yeah, from the date of the
You
arrest.
need the hearing device.
Yeah.
You're leaning in a lot, I just,
Yeah, I'm trying to hear you.
Just use,
Well,
just use the hearing aid.
I'm not upset about it, Mr. Carter. I just want to make sure you're hearing me okay. And I don't want to shout because even when I'm getting a little louder right now, I can hear kind of the echo coming back at me.
Yeah, I apologize, I'm just wore out.
You don't have to apologize, Mr. Carter, but I appreciate that. All right, did you go over this sentencing agreement with your lawyer?
Yes, sir, I did.
Did you understand and sign it?
Yes, sir, I did.
That's a pretty big signature you got there.
Yes, sir. My father was a big man in this town with the Sheriff Ray Wilson in the day.
I'm just talking about your signature,
Yeah.
Mr. Carter.
Yeah.
All right, are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Oh, of course not.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in exchange for your plea?
No, sir.
And do you understand by entering the plea there won't be a trial of any kind and you're giving up your trial rights, which are on page 2 of that agreement that you signed?
Yes, sir, that's fine.
You understand you're waiving all potential defenses?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
Yes, sir.
And what is your plea to the lesser included misdemeanor battery and the assault on a person over 65?
No contest.
No contest.
All right, I'm accept your no contest plea as freely, voluntarily, and knowingly given. On count 1, which is misdemeanor battery, Florida Statute 784.031A1. I'm going to adjudicate you guilty, 8 months in the county jail with credit for time served, and that'll be concurrent with count 2, which is an adjudication of guilt, 8 months in county jail with credit for all time served, a total of $622 in court costs, $100 cost of defense. I'll give you 90 days from the date that you are released to pay that or set up that payment plan. I'll need your fingerprints, Mr. Carter, and then you have 30 days to appeal the judgment and sentence.
Okay. Oh,
Okay.
that means.
Can't do any better than that.
Okay,
You're good.
all right.
Thank you, Your Honor.
Thank you.
Mr. Castile, right? Okay.
Yes, it is.
Do you need a copy of the competency evaluation report?
Yes, please.
Your Honor, this is Mr. Jeffrey Castile. He's before the court in 25 CF 748. We did get a competency report back, Your Honor. It's recommended he found he'd be incompetent to proceed. Does the court have a copy of it?
I do not.
Okay, may I approach, Your Honor?
Yes, sir.
And defense is fine stipulating to the report and allowing the court to make its findings based on the report, Your Honor.
Mr. Sheik.
The state, the state can stipulate to it as well, Your Honor. But I know if you need more time, we could pass it to second.
Thank you.
All right, so we all agreeing basically that as recommended by Dr. Zeman, that not only he be found incompetent, but that he be placed involuntarily into the state hospital.
I am, Your Honor.
The state is as well, Your Honor.
All right, based on the party's stipulation to the report written by Dr. Zeman, I'm going to find that Mr. Castile is incompetent to proceed. Find that there is a concern about imminent threat to dangers to himself or others, and have him placed with the Department of Children and Families into one of their facilities for purposes of competency restoration.
All right, does the court needs an order, correct?
I need
Your
an
Honor?
order
Will
on
do.
both of those issues.
All right. Do we need another court date for him at this time, or no, Your Honor?
I don't think so, but just keep a track on when he gets transported if you can, because I think that's seemed to be more of an issue with females from what I've heard, but I still would like to know if there's any sort of unnecessary delay in those transports.
Will do, Your Honor.
Thank you.
All right, there, Juan.
Yes. And just for the record, Castile's evaluation will be filed under seal. Thank you.
Thank you, Your Honor. Your Honor, this is Mr. Andrew Cato before the court in 25 CF 970. We've reached a resolution in this matter. Just one thing of note, Ms. David, his public defender over with his juvenile cases, had asked if we could potentially wrap up some of his probation requirements, including restitution, into this agreement. It's not currently contemplated here, Your Honor, but if defense were to submit a motion to modify and the state were amenable to it, would the court be willing to consider that? Otherwise, I'll just cross that language out, Your Honor, and we'll just move forward with the agreement. I've explained both situations to Mr. Cato.
You're saying like put his juvenile.
Some of the, like, there's a restitution still owed over there and a couple of other things. We were going to see potentially about wrapping that into this probation. Again, if the court doesn't wish to complicate things, I understand. I'll just cross out that language and we'll move forward with the agreement as negotiated.
Yeah, if you're talking about something like restitution, I'm not sure I can put restitution from one case into another.
Yeah, that's fine, Your Honor.
I'm not trying to be difficult.
No,
but at the
no,
same
that's why
time,
I'm asking, just so I don't confuse the court or Mr. Cato. So I'm going to cross that language out, Your Honor. So you'll just deal with that over in juvenile, and I'll let Ms. David know. Okay. All right, may I approach, Your Honor?
Yes, sir. Probation concurrent or consecutive?
Consecutive, Your Honor, and I believe it's mentioned in there.
I'm missing it somewhere. All right, Mr. Cato, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir.
All right, can you state your full name and date of birth, please?
Andrew Cato, 2007, February 2nd, 2007. My bad.
February 7th, 2007?
Yes, sir.
Okay. Well, you're 18 years old, is that right?
Sir.
All right. Mr. Cato, you're here in 25 CF 970, where you're currently charged with felony battery, third-degree felony, and resisting without violence, which is a first-degree misdemeanor. Do you understand that? All right. I've been given a plea and sentencing agreement that calls for you on count 1 to plead to a lesser included offense of misdemeanor battery. You get 11 months, 29 days probation, adjudication of guilt, batterers intervention program, no violent contact with Donna Cato, 24 hours of community service, 622 court costs, $100 cost of defense, and then count 2 would also be an adjudication of guilt, 11 months, 29 days of probation. Is that an additional 24 hours of community service, or is
Yes,
that?
Your Honor.
Okay.
One 24-hour slot for each term of probation.
For a total of 48.
Correct, Your Honor.
Okay. Also 24 hours of community service on that one. Mr. Cato, that will be consecutive, both the probation and the community service, and then waive costs of supervision. Is that what you wanted to do today, Mr. Cato?
Yes, sir.
Have you gone over this form with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
And are you satisfied with your attorney's advice and representation?
Sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
And has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering a plea there won't be a trial of any kind and you're giving up your trial rights, which are on page 1 of this, I'm sorry, page 2 of your agreement? You understand that?
Yes, sir.
Hold on just a second.
So the court's aware of what they were asking, Your Honor. No violent contact was contemplated in the agreement that the state and I made here. Again, he is dealing with juvenile cases. I can't speak to the exact terms of what's going on over there. But in our agreement, it is contemplated that they'd be able to live together and that no violent contact would be what is sought by the victim.
So what I'm hearing that I'm not hearing is that there may be a condition in his juvenile case that says no contact?
I'm not aware of one. I just want to make sure that I don't misspeak because I'm not intimately familiar with what's
All right.
going on in those cases.
What I'm usually trying to do in this situation is make sure there's not inconsistent orders between two different courts. And then I tell you can do something, someone else tells you can't.
But I'm not aware of
You
one.
have to follow whoever says you can't do something. But I'm not aware of that. All right. Where were we? I'll repeat it. I think we were at the point of where I said you understand you're giving up your right to a trial and you're giving up all your trial rights, which are on page 2.
Yes, sir.
All right. And you understand you're waiving any potential defenses that you may have.
Yes, sir.
And you understand that if you're not a U.S. citizen, this could lead to your deportation. And what is your plea to the lesser included offense of misdemeanor battery and resisting without violence?
Contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. Count 1 is lesser included offense of misdemeanor battery, 784.031A1. It's going to be 11 months, 29 days of probation, adjudication of guilt, batterers intervention program, no violent contact with Donna Cato, 24 hours community service, 622 court costs, $100 cost of defense. Count 2 is also adjudication of guilt to the resisting, 11 months, 29 days of probation, and 24 hours of community service. Those are both consecutive, so basically you're doing 2 years probation, which includes 48 hours total of community service.
Sure.
All right. And waive cost of supervision due to the fact that you've been declared indigent and are represented by the Public Defender's Office. Mr. Cato, I'm going to have you turn around and talk to probation real quick, and then you're going to be fingerprinted, and you have 30 days to appeal the judgment and sentence.
If I may briefly call, before they bring out next, since he's on the docket, Jeremy Childs, Your Honor, 25 CF 1057. He's in custody over in Bay County. I would ask for a continuance in this case, Your Honor. It is his first time up.
How do you get to Bay County?
He was over there dealing with separate charges, Your Honor. He's been in custody in Bay County since the beginning of this case.
All right. October 29th.
Thank you, Your Honor. Your Honor, this is Mr. Seth Krooks before the court in 25 CF 696 and 25 CF 697. Your Honor, I did request a competency evaluation internally. We will await the results of that.
All right. So what are you asking for?
A continuance, Your Honor.
Has that evaluation been set up yet?
The information has been relayed to Dr. Zeman's office, yes, Your Honor. I don't know when the appointment will take place there or when he'll be able to come see him at the jail.
All right, Mr. Crooks, we'll see you back on October 29th, but the doctor's going to come see you pretty soon in the jail.
Fine with that, thank
All
you.
right, thank you.
Your Honor, this is Mr. John Davis before the court in 21 CF 2282. Your Honor, I just entered a notice of appearance in this case on August 8th of 2025. Need some time to get up to speed on it. I'd be asking for a continuance, Your Honor, to the 29th.
You understand that, Mr. Davis? Mr. Davis, did you understand that?
I do. I'm here on no bond.
It's because of a failure to appear, right?
Yes, sir.
Okay.
I'll look into that.
My mother died, my grandfather and my grandmother. I had no, I mean, it was just back to back.
Okay, I'll come talk to you about that.
All right, October 29th, 9 o'clock.
Your Honor, this is Mr. Andrew Delar Roa before the court in 24 CF 1700. Your Honor, we do have depositions set for September 3rd. I would ask for a continuance to the 29th, Your Honor.
No objection.
Would you, September 23rd, did you say?
September 3rd, Your Honor.
Oh, September 3rd.
Yes, Your Honor.
Okay. All right. So you want October 29th?
Yes, Your Honor.
All right, October 29th, Mr. De La Rosa. I'm sure Mr. Maddox will come talk to you after those depositions are done.
Okay. Sorry, who's this?
Dodd.
Ms. Dodd, Patsy Dodd? Okay. Your Honor, this is Miss Patsy Dodd. Forgive me, I don't have a case number, but I just got appointed to this case not too long ago.
It's 25 CF 1184.
Yes, Your Honor. I'd ask for a continuance today to the 29th, Your Honor.
All right, you understand that, Ms. Dodd?
To the 29th of September?
Yes, ma'am. Oh, no, October.
October. I'll come talk to you.
Okay.
Just for the record, what is the state's offer in this case?
State's offer in this case is adjudication of guilt, court costs, 2 years probation, substance abuse evaluation and treatment, and mental health evaluation and treatment.
Thank you. I'll come talk to you about that, okay?
Okay.
All right, if y'all decide to take that and you want to bring it up to a new, sooner court date, you certainly can.
Certainly will, Your Honor. Thank you.
Thank you, Ms. Dodd.
Okay.
Your Honor, this is Mr. Ethan Driver before the court in 25 CF 1189. It is his first time up. I would ask for a continuance.
All right, Mr. Driver, we'll see you back on October 29th. Thank you.
Durham.
Hey, Mr. Chair. Your Honor, this is Mr. Isaiah Durham before the court in 25 CF 1193 and 23 CF 2433, Your Honor. I would ask for a continuance at this time. I believe it's his first time up.
October 29th, it is the first time up, 9 o'clock.
Mayor.
Hey, Mr. Air. Could I have a brief moment, Your Honor?
Yes, sir.
Your Honor, we'll have a resolution in this case, just need to write it up, if you could pass him.
All right, Mr. Air, we're going to pass you till later today. He's going to talk to you about it, have you sign the paperwork, and I'll take your plea later.
Okay. Coming up to see me today?
No, I'll write it up right here and we'll get you back in here. Mr. Russell's handling this case, Your Honor.
Judge, this is Daniel Indicott, case number is 25 CF 717. Mr. Indicott has a bond motion set for tomorrow. We would ask to set this on docket day, September 2nd, for plea or trial.
Your trial.
Yes, sir.
All right, so the bond motion is tomorrow. Then we're going to put it on September 2nd for plea or trial. State going to be ready for trial?
We should be, Your Honor.
Mr. Indicott, we'll see you tomorrow for your bond motion, and then I'm going to put you on for also next Tuesday is docket day, where either you could enter a plea or we'll set the case and give you a trial date in the next 2 weeks.
All right, thank you, Mr. Overs. Sorry I got that FTI, I was in jail.
I'm not sure about it, so but I appreciate your okay.
Ms. Glenn. Your Honor, this is Ms. Latani Glenn before the court in 24 CF 944. We've reached a PTI agreement, Your Honor, just need to get that signed on September 2nd. If we could set it for that date.
That's something we can do later today.
If the state can write it up, I'm certainly happy to do that, but I don't think they have it yet, Your Honor. He was asking if you could do the PTI today or no.
If we pass it, I think I would be able to have time to be able
It's a PTI, I'm assuming that means she'd be getting out of jail, right?
She would be, Your Honor.
So I don't want to pass it just because we don't have time to.
And I certainly appreciate that.
Okay. All right, Ms. Glenn, what we're going to do is bring you back later today, and Mr. Maddox is going to go over some paperwork with you. I want to see if I can resolve the case with you today instead of waiting until next week.
Okay, thank you.
All right, you're welcome.
Sir,
We'll see
fair
you.
judge.
We'll see you just in a little bit.
All right.
Yeah.
Your Honor, we've reached a resolution in this matter, just need to get a signature.
And this is Mr. Hartley?
This is Mr. Randall Hartley, Your Honor. He's before the court in 3 cases, 24 CF 48, 23 CF 2692, and 24 CF 2882, Your Honor. I date it for you. All right. May I approach, Your Honor?
Yes, sir.
That is correct, Your Honor, and also just want to put on the record that part of the reason was also the request of the victim in 23 CF 2692, based off of her request to the state, is also why we downward departed.
And defense did provide the state a mitigation report in the case as well, Your Honor.
Any issues with the alleged victim in the 24 CF 2882?
No, Your Honor.
Okay. All right, Mr. Hartley, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Randall Tavon Hartley. My date of birth is June 20th, 1991.
All right, Mr. Hartley, you're here in 23 CF 2692 and 24 CF 48, which are both violations of probation. And you have a new case of 24 CF 2882, which is a count of battery upon a law enforcement officer, third-degree felony, as well as resisting arrest without violence. Do you understand your current charges?
Yes, Your Honor.
All right. I've been given a plea and sentencing agreement that calls for you to plea as charged. It'd be 11 months, 29 days in the county jail, concurrent with all cases and credit for all time served. Adjudication of guilt on each case, each count, and revoke and terminate your probation. It'd be $967 in court costs on the new case, $100 VOP fee for each of the 2 VOPs for a total of $200. $100 cost of defense in each of the 3 cases for a total of $300, and a $50 application fee. And it says 180 days to pay, but what I would do is 90 days from the date of your release. You've got to either pay or set up a payment plan with the clerk's office.
Okay.
Yes,
Does
Your
that work for you?
Yes, Your Honor.
Okay. All right, Mr. Hartley, have you gone over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Yes.
And did you understand it?
Yes.
Did you sign it?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No.
Currently suffering from any mental health issues?
No.
Are you satisfied with your lawyer's advice and representation? Do you understand that by admitting to your violations of probation, there won't be a hearing where the state would have to prove that you violated your probation?
Yes.
Do you understand by entering a no contest plea in the 24 CF 2882 case, there won't be a trial of any kind?
Yes.
Do you understand that you're waiving your trial rights, which are listed on page 1 of the document that you signed?
Yes.
I'm sorry, page 2. Do you understand you're waiving all potential defenses that you may have?
Yes.
And do you understand that if you're not a U.S. citizen, you could be deported because of this case?
Yes, Your Honor.
Okay. And is this the state's agreement that I've previously announced?
It is, Your Honor.
Okay, and it's a downward departure based on an uncoerced plea bargain with the state?
Yes, Your Honor.
Okay. So what that means, Mr. Hartley, is you scored prison, but because you were able to work out a plea bargain with the state, that's not going to happen. Do you understand that?
Yes, Your Honor.
All right, and what is your plea to the violations of probation? Are you admitting or denying those?
Admitting.
All right, and as far as the new case, battery upon law enforcement officer, third-degree felony, punishment up to 5 years in state prison, and the resisting without violence, which is a misdemeanor, what is your plea to those two?
No contest.
I'm going to accept your admission to the violations of probation as well as the no contest plea. In all cases, all counts, it's going to be 11 months, 29 days county jail, concurrent and with credit for all time served. Be adjudicated guilty on each of the cases and counts. Revoke and terminate your probation in the 2 VOP cases. In the new case, $967 in court costs. The $100 VOP for each of those two for $200. $100 cost of defense for each case was $300. And the $50 application, as I stated previously, I'll go ahead and give you 90 days from the date of your release to make the payments of those costs or set up a payment plan.
Yes, Your Honor.
Any questions about that, Mr.
No.
Hartley? No? Okay. I need you to be fingerprinted, and you have 30 days to appeal the judgment and sentence of the court. I think I said revoke and terminate, but just wanted to make sure I said it again.
Appreciate that, Your Honor. All right. Your Honor, this is Mr. James Chad before the court in 24 CF 2922. Your Honor, we reached a resolution in this matter. Just so the court is aware, we were also in contact with Ms. Flowers, Ms. Flowers, right?
Yes.
With Ms. Flowers about resolving her 2 misdemeanor cases. We did, both Mr. Sheik and I coordinate with her and coordinate with Mr. Hall, his public defender on those cases, Your Honor, and we're prepared to resolve all of them if the court is amendable to that. Sure. All right, thank you. May I approach?
Yes. Well, I'm going to look at it, but I'm willing to take a look at it first. Can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your name and date of birth?
Chad James, December 18, 1982.
Mind if I change your name on the style of your case so it's
No.
Chad James instead of James Chad?
Yes,
You got it reversed.
that's fine.
Sorry about that, Your Honor.
By all means.
Glad you caught that.
I think you said it that way, so that's what kind of tipped me off, and then I looked, and that's the way it was. All right, so Mr. James, you're here on 24 CF 2922, possession of controlled substance, third-degree felony, as well as 2 misdemeanors that we're going to handle from county court, which is 25 MM 2522, violation of injunction and drug paraphernalia, 25 MM 2523, another violation of the injunction. The plea calls for you to plead to 24 CF 2922. You'll get credit for time served, withhold of adjudication, $615 court costs, and $150 cost of defense. In the 25 MM 2523, to be an adjudication of guilt, 11 months, 29 days of probation, special condition abide by the injunction, $270 in court costs, and a $50 cost of defense. And then the state's going to dismiss 25 MM 2522. Is that your agreement?
Yes, sir, it is.
All right. Has the state had a chance to speak with the petitioner and the injunction?
Ms. Flowers has, Your Honor.
Okay. And any issues with that?
No issues.
Okay. All right, Mr. James, did you go over this plea and sentencing agreement with your lawyer? Did you understand and sign it?
Yes, sir, I did.
Are you satisfied with your lawyer's advice and representation?
Yes, sir, I am.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir, I'm not.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter the plea?
No, sir.
Anyone promise you anything in return for the plea?
No, sir.
All right. Do you understand that if you enter the plea, there won't be a trial of any kind?
Yes, sir.
And you give up your trial rights, which were listed in the agreement you signed?
Yes, sir.
Do you understand you're waiving any potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation? And what is your plea to the one violation of the injunction, possession of drug paraphernalia, and possession of a controlled substance?
No contest.
All right, I'm going to accept your no contest plea in 24 CF 2922. Withhold adjudication, credit for time served, $615 court costs, $150 cost of defense. In 25 MM 2523, it's going to be an adjudication of guilt, 11 months, 29 days of probation. You're to abide by the injunction, $270 in court costs, and a $50 cost of defense. Let me make sure I understand this now. So we've got one felony case. I'm handling 2 cases from county court. He's getting probation for the county court case, but he's getting felony probation for it.
Correct,
But he's not getting probation on the felony.
That's correct. The intention was to have state probation supervise it, and that was the resolution we reached, yes, Your Honor.
Probation have any issues with that?
As long as I can take it out of state with the injunction, I'm not living with my wife currently.
I'm sorry.
I'm not living with my wife currently.
No, but you said something about
yeah, out of state. Yes, I live in Mississippi currently. When I spoke to the probation officer last time, she said it wouldn't be a problem. They can transfer it.
Well, they can transfer. Were you living in that state when this happened?
Well, not when the injunction was filed, but
Well, no,
for the past year,
when the
yes.
violation happened.
Yes. Yes.
Probation, any concerns?
No.
No, I'm asking
Okay.
probation
Oh,
behind
I'm
you.
sorry. I thought he was looking at me. I apologize.
I'm looking.
I do. I have a driver's license.
Okay. I just want to make sure that it's not going to cause any other issues because you're really only going on probation for a. Yes, ma'am. That's why I was asking. It's kind of a unusual way of doing it. But if obviously I'm not in county court, would JCS probation allow him to live out of state and be supervised that way?
They never gave us an issue with it when we did it that way, Your Honor.
I think the problem is he's ultimately doing probation for an MM case. But doing it in felony court is going to jam him up. Again,
Well,
I don't mind doing the things, but I think it's going to cause you more problems than it fixes, Mr. James.
Well,
Kind of like your name, and we might have it reversed at this point. Well, I'm not trying to give advice here. I just want to make sure we're talking it all out. If he's doing the probation on the felony case, if he's to violate, he has a lot more exposure.
the intention was to have state probation supervise him, Your Honor. I apologize that we've screwed up the logistics here, but that was the intention all the way through. I just spoke to my client. But he's fine doing a year of probation concurrent on the felony charge, Your Honor, to avoid this issue. So that he can have the transferred over to Mississippi, where he was residing.
Instead of the other potential option, which is just have him plea as is to time served on my case and then have county court put him on probation with JCS. And I'm not trying to encourage that or discourage anything. I just want to make sure that I can tell you from my 15 years of doing criminal defense before I took the bench is I always ask probation these kinds of issues ahead of time because it can be a sticky situation if we don't handle it right. And I'm trying to make sure that I almost called you Mr. Chad, Mr. James, that we don't do anything that's going to be kind of artificially difficult for no reason. Y'all want to talk about it for a second? I don't like to rush into this.
Yeah, that's fine, Your Honor. Just pass him so that I can go over everything with him, reassure him, and
All right.
we'll go with that. I appreciate that. That's
Mr.
fine.
Maddox, I'm going to give you this back in case you need to talk to him about the paperwork. We'll call you back up later, Mr. James, just to make sure everyone's on the same page. Maybe reach out to JCS or one of the misdemeanor attorneys to see if they can give you any advice on that.
Yes, Your Honor.
I didn't realize it was probation only on the misdemeanor MM case.
Hey, Mr. Moore. Your Honor, this is Mr. Jeffrey Moore before the court in 24 CF 2894, 24 CF 1357, and 24 CF 1358. Your Honor, we're still working on getting the dates coordinated for the motion to suppress in the possession of controlled substance case. So we're working on that, Your Honor. What I would propose, if the state's amenable to it and the court is amenable to it, is going ahead and setting the aggravated animal cruelty case for trial and setting the motion to suppress for the possession of controlled substance case on the back end and trying that case after we deal with that motion to suppress, Your Honor, because that would allow us to take care of the dispositive motion to suppress, whichever way the court goes on it.
Let me make sure I understand what you're doing, Mr. Max, because you're saying the possession of controlled substance case, but two of the cases have a possession charge. I think we severed
Yes.
24 CF 2894, which is the animal cruelty case, but also a possession of controlled substance.
Correct.
I believe last time around, we had set that animal cruelty case for trial, right?
We were trying to get both set for trial if possible, Your Honor, but we had originally set the possession of controlled substance case. I then filed the motion to suppress, so we continued it, and then we've been trying to get the motion to suppress set since.
You're saying the possession case, but which one?
The possession count.
Possession count.
Yes, Your Honor.
So we're only really talking about the 24 CF 2894.
Correct, Your Honor.
Okay.
The other two are VOPs, the other two cases.
Oh, I got you.
Okay, sorry.
I did not, that's my fault, I didn't write VOP on those two.
And, Your Honor, the state would propose, because the issue with the motion hearing is the availability of the doctor in the case to determine whether or not there was probable cause to make the arrest. And so making sure with her schedule. And she's going to be a crucial individual for the animal abuse case. So we would propose that we set the motion in the trial week so we can just get rid of that, because if we find out at that point that there was no probable cause, in that case, we most likely wouldn't go to trial on the case if there wasn't even PC at the time. So if we would propose that we do that motion hearing first during the trial weeks, Your Honor.
We'd have the motion hearing. If I determine that there was probable cause for the search that led to the possession charge, that would mean you're going to go forward with the animal abuse charge as a trial.
The state is intending to go forward with everything, so we would be willing to go forward with that as well. We're not limiting it. I just think we should.
I'm just trying to figure out how we're going to do that, where we're going to have a motion hearing that has to be decided on the fly, and then somehow it's going to be a jury trial that same week.
I agree, Your Honor.
Because we continued this last cycle in order to deal with this motion to suppress, and then
Correct.
Here we are.
Yes.
Basically 2 months later and haven't really done either one.
Well, we had it set for a date. The doctor was unavailable on that date, Your Honor, and since then we haven't been able to coordinate a date that works exactly for the doctor and for the officers involved, and so that's the issue here. I did let Dr. Ward know that this case was still pending and that, we still would need her to come in for a motion to suppress. I do think we could get that motion to suppress set sometime relatively soon, try the controlled substance case the next cycle, and try the aggravated animal cruelty case, which definitely still needs tried, and there are issues in that case this cycle, Your Honor. I would be ready to go, assuming, of course, you still...
But what Mr. Sheik said is that if we have the suppression hearing,
Yeah.
and I make a determination there was no probable cause to make the arrest on the animal cruelty charge, well, then they're not going to go forward with that trial. So don't we kind of have to have the motion hearing before the trial?
Well, that's true as well, Your Honor, yes.
Yeah, I mean, based off of the findings on that one, it will determine how we move forward on the other ones, Your Honor.
All right, but that's why I don't really want to be in a situation where we're somehow going to squeeze a motion to suppress into a trial week and then, pick a jury that same week?
Okay. Yes, I understand, Your Honor.
So why don't we do it this way? Put it on Tuesday for a plea or trial. See what y'all can figure out as far as coordinating the doctor for purposes of the suppression hearing. But I don't like the idea of trying to put a suppression hearing during the trial weeks, because I may need all those days for trial weeks.
Sure.
Yes, sir.
And it kind of puts it in a situation where we have to have that sequence of events, which may just not work logistically. Maybe it will, but I think it needs a little more thought put to it first. So what we're going to do, Mr. Moore, I'm going to put you as a potential trial still, but so that everyone can prepare for that. But y'all need to figure out what you're going to do about this motion first.
And we'll be going forward, I would assume, on the animal abuse or the animal cruelty case, if just to make sure we have the subpoenas for that one, Your Honor.
That's what I'm hearing.
Yes.
But my concern is if we set that case for trial and you can't get the doctor in for the suppression hearing, are you going to go forward with the trial having not had the suppression hearing?
Well, and that's my point on there, Your Honor, is the doctor is necessary for both the motion hearing and the trial.
So
I'm going to put it on for Tuesday. Between now and then, y'all are going to talk to the doctor's office to see if you can't get, I think you said her in to testify to something. Otherwise, I don't want to set cases for trial, subpoenas go out, jurors get summoned, just so it all gets kind of blown up because we can't get the doctor in. But see what y'all can do about that. But I'm going to put it as plea trial.
Thank you, Your Honor.
All right.
Just out of curiosity, Your Honor, and just maybe to have something firm to take to the doctor, how is the September 25th docket looking in terms of time? Because we could potentially squeeze it in there.
But that would be after the trial period.
That would be after the trial period, though, yes, Your Honor.
Trial would have to be continued.
Yes, Your
It would be, yes. But at least that would give me a firm date.
I think I have 2 hearings in the afternoon after the arraignments. Trying to remember what the second one is because it just got set today. Do you remember? McGee. Which one's that? With Miss Dudley, yeah. I have that listed as 9:25. I have that as a trial this time. Thomas. Cordell Thomas. It might be kind of tight on the afternoon of the 25th. Just because I've got one case that I was just given that's 5 years old, and we've got stuff going on that day, and then I've got a suppression motion with Mr. Cobb on that afternoon as well. I mean, I'm certainly willing to try, but it'd be hard to bump people who are already there if that's the only time they're available. But I would guess, again, talk to the doctor's office, see if you can't find a day that works on one of my normal motion dates. And let's rally back up about it on Tuesday.
Your Honor, on Thursday and Friday, if I can't get a hold of her and get a bunch of dates from her, and get that over to the state, and then get that to the court as soon as I know some dates that would work.
I just want to do things in the proper sequence based on what y'all have told me.
And that's fair.
All right, so we'll put you on for September 2nd, which is next Tuesday at 9 o'clock, and we'll see if they get this figured out in the meantime, Mr. Moore. All right, we'll see you then.
Vernon Robinson. Your Honor, Mr. Robinson, this is Mr. Robinson before the court in 25 CF 577. Your Honor, if we could set him for September 2nd for resolution.
So what are we calling that? Plea or continue, plea or trial?
It's going to resolve, Your Honor.
Plea or continue. I'm pretty sure it's mostly there's a companion case, and I just need to make sure and discuss with the other prosecutor on that case before I resolve this one, Your Honor.
Okay. All right, next Tuesday, we'll see you, Mr. Robinson. It's going to be September 2nd. They're saying it's going to resolve
thing in the
that
morning?
day. Say again?
First thing in the morning?
Well, I'm going to put you at 9 o'clock, but we're going to have
Thank
a whole
you.
bunch of cases. I typically let them call which cases they want to call first.
Thanks, Mr. Robinson. Your Honor, this is Mr. Strafac before the court in 25 CF 440. I have down in my notes that the state requested a second eval, or was set to request a second eval, Your Honor.
That's what I have.
I'm not sure what the stats of that, but I didn't see one.
I can tell you I have not requested that, Your Honor. I apologize. If I can just have a moment, maybe push this case and I can review it and we can hopefully come, that way we're not spending an entire trial cycle resolving something, Your Honor.
Yeah, I don't think I need the apology. So we'll pass it and we'll bring Mr. Strafac back up once the state's had a chance to take a look at it. We're going to see you later today, sir. They just want to take a look at it and see what they can do to expedite the situation. All right, we'll see you in a little bit.
Hey, Mr. Webb.
State's attorney.
Your Honor, if we could set Mr. Webb for September 2nd for possible resolution, Your Honor.
Sir, you're calling that plea or continue?
Yes, Your Honor. The issue with Mr. Webb, just so the court's aware, because I know this one's getting a little old, is trying to get him into a treatment program, Your Honor. We've applied for Phoenix House, unfortunately got rejected. We applied to Keaton, unfortunately got rejected. And then the state's mulling over the situation based on that. We may also be able to squeeze in an evaluation before the 2nd for what's Orthodox? Some other
Oxford
program.
House, I
Oxford
think.
House.
Oxford House.
Thank you.
In Escambia County, or
No, it's in Fort Walton Beach.
they have one here too?
Yes, Your Honor.
They've got a lot of them in Escambia County, that's why I asked.
Yeah, we were informed today
You-
that there is this possibility.
Usually the concern is violence charges. That's probably why he's being rejected everywhere,
That's correct,
right?
Your Honor.
Well, just, let's look into to see if that's going to be just a disqualifier before we go through all the process.
Well, my understanding was it was possible potentially that he could get in, so I did at least want to apply and have an affirmative no if that was going to be the situation, Your Honor. And again, we were looking into other programs as well, and now we have Oxford House as a possibility. Otherwise, Your Honor, we had, the state was potentially willing to offer something else if he wasn't able to get into any programs. So we were still moving forward on both fronts and considerations.
Yes, Your
I
Honor.
just, sometimes it's like an immediate disqualifier in those programs. So you might want to just take a peek at that before doing the applications.
Yes, Your Honor.
Yes,
All
Your
right.
Honor.
Thank you. We'll see you back. Do we want to bring him back next week?
Please, on the
September 2nd,
yes.
please.
September
Your Honor.
2nd. All right.
Thank you.
Clear continue on September 2nd. We'll see you next week on Tuesday, Mr. Webb.
Thank you, sir.
And Cordell Thomas, Your Honor, we dealt with earlier, 24 CF 2845.
Yes.
Is that everyone? Okay, perfect.
Does anyone have Delon Thomas?
Yes, Your Honor.
Okay, it's just, my docket says Jason McKinney.
Well, Your Honor, and that is something that I was going to talk to Mr. Thomas about. Apparently, this was transferred down south, and then there was a decision that it wasn't going to be down south, and then now it's back up, and so I just recently found out myself.
Being ping-ponged back and forth.
Yes.
Why? She pled on the 31st.
And Your Honor, while they're getting the next person, if I could address someone?
Sure.
Your Honor, on Monday, we had James Mullen, 24 CF 2918. I had indicated that I couldn't understand why he wasn't here because he's very responsible, always makes his appointments and court appearances. There was a lack of communication in our office. We had filed a waiver of appearance for him back in July.
That was James. Mullen?
James Matthew Mullen, 24 CF 2918.
Yeah, I think we had set him for Tuesday.
Yes, Your Honor. This is the one who lives in Mississippi.
Okay.
So I'm asking the court that since that was an error on our part, that there was a waiver, that we not now have him come and just continue his case till the October court date.
He's okay with that.
Yes, Your Honor.
Case is getting a little older, though.
Yes, Your Honor, there's a couple of unique issues that have come up in that case. This was the case with Dr. Zeman, where we kept trying to get him to make a decision and to write a report. And he now has finally done that.
You have the report?
Yes, Your Honor. And we are going to be filing a not guilty by reason of insanity based on that report.
We'll cancel September 2nd, put him on October 27th.
And if the
1
court would
p.m.
recall the capias, please.
I don't think there was one.
Okay. Oh, that's correct.
I think we put it
That's
on just
correct.
for status
Yes.
because there was a concern that
Yes.
he was normally here, so I said, get him here on Tuesday.
Yes.
Or I'll issue the capias.
Yes.
But
Thank
just, I guess I'll say it just in case. If I did issue a capias, which I don't think I did, I'm withdrawing it.
Yes, sir. He apparently has been paying attention, watching. Yes, and call our office. Your Honor, this is Derek Lewis before the court on 23 CF 2797. We're still waiting on the report from FDLE.
We just got it
We did?
today.
Today?
I got it today, and we were sharing it with you.
Okay.
And it's obviously confirms Mr. Lewis's DNA.
Okay. So, Your Honor, I would need to get a chance to look at the report, so I guess we would just plan for next time.
This is from December of 23.
Yes, Your Honor.
You want to try and take a look at it first to see if there's something worth discussing
Yes, Your Honor.
before
That's
we
fine.
put it off for another 2 months?
Yes, Your Honor.
All right. Why don't we do this, Mr. Lewis? We're going to have you come back next week on Tuesday. That way your lawyer can take a look at the DNA FDLE report, talk to you about it, see if what y'all want to do from there.
We set it for trial, Your Honor.
Rivers?
I would need to speak with my client.
Well, it's just that they got to get their subpoenas out if we're going to set up for trial.
Well, again, I would want to be able to look at the report, go over it with my client, then let him make an informed decision based on that.
Why don't we just put it down for plea or continue then?
Thank you, Your Honor.
Sounds.
All right. But unless you tell me there's something else that needs to be done,
No, Your Honor.
This would be the
last
Yes.
only
continuance.
thing.
Yes,
The positions
Your Honor.
have been done, so.
Yes, Your Honor.
All right, so last continue, well, it'll be the last continuance if it's continued, but it's going to be plea or continue on September 2nd, next Tuesday.
Yes, Your Honor.
All right. Now that I've thoroughly confused everyone.
You haven't, Your Honor.
We'll see you next week on Tuesday, Mr. Lewis. Hopefully, Mr. Rivers can come talk to you about what that report says, and then y'all can make a decision if y'all want to try to resolve the case or continue it so we can set it for trial next time. Okay. Who's that?
1, 13, and 14 on your docket, Judge. Judge, this is going to be Jonathan Paul Collins. Case numbers for the record are 25 CF 1041, 24 CF 2510. We've got depositions set for both cases for October the 14th, so at this time we're going to ask for continuance to the 1029 date.
October 29th, 9 o'clock for pretrial.
Your Honor, this is Diana Malone, 21 CF 923. We do want to announce ready for trial.
State?
Ready?
Ready for trial? Okay. And this is the,
Not guilty by reason of insanity.
so we'll come back on Tuesday, the 2nd, for docket day, just to make sure everything's set up for the trial.
Yes, Your yes.
All right.
Yes, ma'am. We've reached an agreement in this matter. If we may approach, Your Honor, that's Jared McGowan, 25 CF 750.
All right, Mr. McCown, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
You state your full name and date of birth, please.
Jared David McCowan, 3/22/89.
Mr. McCown, you're here in 25 CF 750, where you're charged with fleeing and attempting to elude a law enforcement officer, third-degree felony, and resisting without violence, first-degree misdemeanor. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that calls for you to enter a no-contest plea as charged. Those two counts would be an adjudication of guilt. Count one, 2 years probation. Count one, 2 years probation. Count two will be 1 year of probation to run concurrently. Comply with the Emerald Coast Life Center or complete a substance abuse evaluation and any recommended counseling. $515 in cost, $100 PD fee, $50 application fee, and waive cost of supervision. Is that your understanding of the agreement?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Did you go over this agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Very much so.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea?
Yes, sir.
All right. Do you understand that if you enter a plea, there won't be a trial of any kind? And do you understand that you're giving up your trial rights, which were listed in the agreement that you signed?
Yes, sir.
And do you understand you're waiving all potential defenses?
Yes, sir.
And do you understand if you're not a U.S. citizen, you could be deported because of this? All right. And what is your plea to the fleeing and eluding a law enforcement officer and resisting without violence?
Contest.
All right. Is that the state's agreement?
It is, Your Honor.
All right. I'm going to accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty. On count one, it's going to be 2 years of probation. On count two, it's going to be 1 year of probation, concurrent with count one. Comply with ECLC or complete a substance abuse evaluation and any recommended counseling. $415 court costs, $100 cost of prosecution, $100 PD fee, $50 application fee, waive cost of supervision due to the fact that you're indigent. This is a guideline sentence based on the amended guidelines that shows 36.5 points. All right. Anything that I've missed?
No, Your Honor.
All right, Mr. McCowan, I need you to talk to probation first, then be fingerprinted, then you've got 30 days to appeal the judgment and sentence. All right.
Oh, there.
Okay. Can we address Mr. McCowan on his other case?
I'm sorry?
Mr. McCowan's other case?
That
was a suppression motion
Correct.
that I granted.
Correct.
I think you made an oral motion to dismiss, which I granted, but
Correct.
we need a written order on that, if you could send that over. And then I just want to follow up with that was your case too, right? We had talked about whether or not you wanted a written opinion on the suppression issue.
Yes, sir.
You want one?
Please.
Okay.
Your Honor, this is Tyan Morris, 22 CF 1436. This is Mr. Williams' case, and he has stepped out to the printer. I'm going to ask that
Wait,
he
this
just
is-
be
Who's this?
Tyan Morris.
Okay, I've got it listed under you, that's why I was confused. Go ahead.
Yes. No, Your Honor, that this would be Mr. Williams' case. I would ask that we just put it on for 9/2.
Mr. Williams.
Oh, he's back.
Okay.
Judge, there is some confusion. The case that was on the preliminary clerk's docket, actually, I didn't have a record of being appointed to yet. Let's just get me appointed to all the cases and continue them, and we'll work them all up. And if they need to get ready for trial, we'll get them ready for trial. If we can get them worked out, we'll get them worked out. But I've met with Mr. Morris before. I think he's just kind of wanting everything to finally get packaged together where he knows who's representing him and
So you've got
somebody's working the case.
the other three cases. So
Yes, sir.
That's going to be 22 CF 1436, 23 CF 2394, 25 CF 1174, and 1175. Those are all yours, right, Mr. Williams?
Yes, sir.
For the most part, at least a couple of them are brand-new cases.
Yes, sir.
All right, so you want October?
Yes, sir.
October 29th at 9 a.m., Mr. Morris. We'll see you back on that date.
Thank you.
I'm sure Mr. Williams will come out to see you soon. All four.
Your Honor, this is Shane Morrow before the court on 21 CF 2674, 21 CF 2998, 22 CF 273. I had filed a motion to compel for discovery,
In which case?
and that would be in the two cases, the 2022 CF 273 and the 21 CF 2674. Ms. Basso did hand deliver a disc to me on Monday. And we have depositions set on September 22nd. We had our motion set for tomorrow.
Okay. My system's still showing that was already found guilty in 273, but it's come back on appeal, right?
That's correct, Your Honor.
Okay. It's like, why is it showing that he's guilty, all of his
Yes.
cases already resolved previously?
Yes, Your Honor.
Oh, did all of them come back or just that one?
That's correct, Your Honor. All three of the cases came back.
Okay.
It would be a violation of probation on 21 CF 2998 that would be before the court. And then the other two cases are new law cases that have come back. And I did file my motion to compel for the discovery. It was hand-delivered in
Monday.
court on Monday.
Okay. So
And
what
we
do you
have
wanna-
depositions set for 9/22.
9/22. Sorry, I missed some of that. I was trying to figure out why I was showing him as guilty. I guess they don't go back and take that out of my system, at least, when it comes back on appeal, but maybe they should. All right, so do you want the October date?
Yes, Your Honor.
All right, October 29th at 9 o'clock. But I know you've done everything you can, Ms. Rivers. Let's make sure this is progressing since it's such an old case because of the reversal.
And, Your Honor, would that be at 9 o'clock or would that be at 1 o'clock? Mr. Russell had indicated y'all were talking about
I
1.
simply brought it up as a, what do y'all think about that? But I didn't want to make any concrete decisions quite yet.
Yes,
It
Your
just
Honor.
seems that in our pre-trials and in custody days, we're seemingly getting to like a perfect separation around the lunch hour when we get to the PD cases. And like I said, it doesn't matter to me because I'm here the whole time. I'm just trying to figure out, do y'all want to be here the whole time? Then you've also got potentially people, family members and things who are coming to see defendants who may be sitting here for 6 to 8 hours. So I just want to kind of throw it out there as a suggestion. Y'all tell me what y'all think, and then I'll make a decision if we're going to do that or not.
Yes, sir.
All right. 9 o'clock.
Thank you, Your Honor.
Oh, I'm sorry. Yes, 9 o'clock.
Thank you, Your Honor.
Thank you. We'll see you next time.
Your Honor, this is Kenneth Osborne for the court on 16 CF 1542. We have 2 hearings set for tomorrow.
Okay.
In speaking with Ms. Basso, she missed the suppression hearing. So I believe she's going to be asking to reset that hearing. The second hearing is with Mr. Moore, Mr. Osborne's prior attorney.
About the video,
Yes, Your Honor.
has it been found? I'm assuming.
Yes, Your Honor, it has been found, but Mr. Moore would like to have a hearing.
To determine what?
Your Honor, he says that it would be illegal, in his opinion, to produce the material. And he's also seeking monetary compensation.
All right, well, that'll be interesting. What time are we set for tomorrow?
Your Honor, I
2 o'clock?
think it's 2 o'clock.
All right, Mr. Osborne, we'll see you for those hearings tomorrow at 2 o'clock.
Thank you, Your Honor. You have a blessed day.
All right, you too, Mr. Osborne.
Okay. Oh, actually, I do have it right here.
That is not the original search warrant.
That's what he brought. Your Honor, if I may have one moment with Mr. Peacock, because a new condition has possibly been added, so I need to make him aware.
Okay, that's fine. told you, the only time I ever got COVID was because of much smaller courtroom. But.
Your Honor, this is Justin Peacock, 23 CF 2819. We've reached an agreement in this matter, if I may approach. The jail is asking that he be sentenced to 11 months, 29 days of probation, and as a condition of that probation, that he be ordered to complete 11 months, 29 days of Okaloosa County Jail, and that he complete the ECLC, and that while he's in there, he do the ECLC program.
The jail is requesting?
That is correct. Ms. Claw was here. And she had indicated that the jail administration had contacted her and told her that that's what needed to be done.
I'm aware of that, Your Honor, and that's a correct way to handle it. The reason is, if they're doing the program and we don't make it a condition of probation, then there is no violation of probation. And the jail wouldn't know what to do, but in this case, probation would be notified of the violation and then provide sanctions or a warrant for the violation. But if the court has a better suggestion, of course.
Well, I mean, I'm trying to think about it, but I don't think I have a better suggestion at this point. I mean, if it's agreed upon, I'm not too concerned about it, but it's the first I've ever heard that the jail was requesting a particular sanction.
As well as I, Your Honor.
All right. Mr. Peacock, you want to raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sure.
All right. Could you state your full name and date of birth, please?
Justin Peacock, 12/13/85.
All right, Mr. Peacock, you're here in 23 CF 2819. Is the case really that old?
Yes, Your Honor.
What's the reason for that?
Failure to appear.
That's what I thought. I just wanted to make sure. Starting to all blend together a little bit, so that's why I asked the questions. All right, Mr. Peacock, you're here on a charge of possession of ammunition by a convicted felon?
Yes, Your Honor.
So there's no midman because it's ammunition, not firearm.
Correct, Your Honor.
All right. It's a second-degree felony where your possible exposure would have been 15 years state prison. Do you understand that?
Sure.
All right. And the plea and sentencing agreement I have calls for an adjudication of guilt, 11 months, 29 days of probation, with special condition of 11 months, 29 days of jail. Does he have credit, though, or we?
And, Your Honor, he is supposed to get credit for all time he's already previously served, and I don't know how.
Do we have any idea on what that might be?
Do you know how long you've been over here in the jail this time?
2.5 months.
So, because if he gets out before 11 months, 29 days, then he's going to be on probation.
Yeah, and that's the reason why that doesn't work.
Well, it works if we do a fresh 1129. It always works. But if you want credit, then he needs to complete the sentence. You cannot have it both ways.
But it's not on here, so that's why I'm.
And it wasn't contemplated or discussed with him either, so.
Sounds like we don't have a meeting of the minds quite
No,
yet.
Your Honor, no.
I just thought it was an 1129 jail without ECLC, and that's why I was agreeable.
Well, and this is what Ms. Claw came up and told me a while ago.
Has she left?
I guess so.
Yeah,
Your
she's
Honor.
not
She
here.
had been here.
She'd been here pretty much all day
Yes.
until the first time I
Your
looked.
Honor, I would ask for it to just be 11 months, 29 days Okaloosa County Jail, credit for any time served. And we can, in the future, talk to Okaloosa County Jail about the problem that you run into in this situation of people not getting their credit and go from there.
You can ask me, but it's whether or not y'all have a plea agreement. That's why I
Right.
kind of use that meeting of the minds,
Right.
Contract.
Because
terms.
I now keep telling him something different. What I told him earlier, and then when I'm telling him now, and then now.
Well,
what
why don't
we're
we do
saying
this?
again.
Why don't we pass Mr. Peacock, make sure everyone's on the same page, talk about it later this afternoon if we need to. But I don't want to be in a situation where I'm somewhat negotiating these things out. Because it sounds like you might have a bigger, how do we do these in the future type
Yes, Your Honor.
discussion to have between defense and state.
Yes, Your Honor.
Mr. Peacock, we'll bring you back later. She's going to talk to you about it once they figure it out how they want to do it.
Your Honor, this is Payton Pierce before the court on 25 CF 968, 25 CF 971. We are asking the court for continuance to the October 29th court date. We are going to see about setting depositions, whether they'll be able to be set before October 29th. I honestly couldn't tell you. I do know that I have so many depositions booked. I can't, say to the court affirmatively that depositions will be done.
But as long as you
That'll
tell
be
me
the
they've been
intent.
set.
Yes, Your Honor.
And hopefully as soon as possible, so they are done before the next court date.
And I can do that, Your Honor.
October 29th, 9 o'clock.
Out to Your Honor, this is Rocky Robinson before the court on 25 CF 404. In speaking with Mr. Robinson, was it yesterday?
Yes, ma'am.
Yesterday at the jail, there is more information that he wants me to give, and I did list additional witnesses. We did have depositions in this matter, but
August 12th.
August 12th? Yes, Your Honor, that
So
was
you
when the
haven't-
deposition date, yes.
You have new evidence?
He has indicated, Your Honor, that he wants me to look into some new evidence for his case. So I would be asking to put this on the October 29th court date.
All right, October 29th, 9 o'clock. See you on that date, Mr. Robinson.
Yes, sir.
Obviously, if you have anything to provide to her that you haven't, make sure you do that so she can work on it for you.
I've talked to him.
Okay.
Your Honor, the next listed on the docket is Jonathan, on my docket, is Jonathan Russell. It's 3 cases. Mr. Russell pled out on July 31st,
I don't have him on my
2025. Okay, good.
You got it. Okay. Who's this?
How you doing today?
I'm good. How about you?
I'm all right.
Your Honor, this is Mr. Schaffner. Let me click over. 25 CF 1003. We had depositions in this matter. He does have another case, another new case. We are wanting to do depositions on that case and then try to get a joint resolution.
Is that new case mine?
Yes, Your Honor.
Yeah, I think it's on for tomorrow, Your Honor.
Oh, for arraignment.
Yes, Your Honor. But we have completed depositions in this case. I am going to be asking for the October 29th date so we can go ahead and address that other case as well.
What are the charges on the new case?
Grand theft auto, criminal mischief, driving while license suspended, or no valid license. It's one of those two.
All right, Mr. Schaffner, we'll see you back tomorrow for your new case, but otherwise, this case will go on October 29th.
All right, thank you.
Did we skip one?
Yes.
Scott, did you skip?
I was just going how they pulled them out.
Okay, I just wanted to make sure that.
Have a moment, Your Honor.
With?
With the state.
Go ahead.
Your Honor, I believe we've reached an agreement in this matter. I'm going to need to draft it up.
All right, so bring it back later today.
Yes, Your Honor.
All right, ask for plea.
So if we could keep him, thank you. And I'll write it up, all right? Mhm.
See you later this afternoon, Mr. Smith.
Your Honor, this is Richard South, 23 CF 1796. We've received all the additional material that we had needed for this case, and we are ready to announce, ready for trial.
It is ready, Your Honor.
All right, Mr. South, we'll see you back next week on Tuesday the 2nd for your what's called docket day, just to make sure everything went well with setting things for trial. But then we'll set your trial date for one of the next 2 following weeks.
So everything's just as we talked about. You're set to go to trial. Okay. Mm-hmm. Your Honor, this is Blake Spithe. He's before the court on 25 CF 889. Ask for a continuance to the October date with anticipation of setting depositions.
All right, October 29th, 9 o'clock. Oh, let's get those depots set. DOC as well.
Your Honor, this is James Strickland, 25 CF 864. We had depositions just recently. In depositions, we learned that there is a veterinarian report. There are photos, all of things we do not have. We are requesting a continuance to the October court date. Give the state time to produce that information, and then we can assess how we want to proceed.
We're gathering it right now, Your Honor.
Well, one of the witnesses told you about them, but the state never had them either?
Correct.
Correct, Your Honor.
That would be the police officer, Your Honor.
It's always my pet peeve when I was practicing. October 29th, 9 o'clock. We'll see you back on that date, Mr. Strickland. But let's see if the state can expedite those things.
Yes, Your Honor.
Thank you.
This is Delon Topps.
Yes, ma'am.
All right. So apparently they said your case is going down south. They sent it down south. Now it's being sent back up. So I am going to be your attorney from this point forward.
Yes, ma'am.
But I haven't been out to see you.
Jason McKinney, could you tell him to check
I did. I remember that. All right.
Why was it transferred?
Your Honor, I don't understand why it was a lower case number. my understanding that that was a decision made by the clerk. I could be wrong, but that was not,
This is 1284, and there's also 1316.
because I believe we were in here once before, and I had conveyed to him that Mr. McKinney would be his attorney, and then we sent him south, and now we're back.
This is this earlier case number, 1284. Happened in Fort Walton.
Yes, Your Honor.
And there's 25 CF 1316. Happened in Crestview.
Your Honor, I think, this was actually the other case that wasn't on for today was the one that I talked to Mr. Snell on, and he had said because I had that one, and I also have the co-defendant, and that's the major case on there, that was the reason we did it slightly different in this case, since the 1316 was one I was already doing the co-defendant on.
I think I understand. So it's either send a co-defendant south because of his other case, or just leave everything up here.
All right.
Makes sense, but a little confusing. All right.
And what he's saying is that your case with Mr. McKinney is going to be up here, and Mr. McKinney's not going to be your attorney anymore, and everything's going to be in front of this judge from here on out. Your Honor, obviously, I'm going to be requesting a continuance considering I've had no contact with this man.
Okay.
But I will be rectifying that.
The 1316 case, I think we talked about sending that to Judge Stone.
And they turned around and I guess Mr. Snell or whatever sent it right back.
Sending this one back. All right, let's just do this so it's clear. Both of his cases, 25 CF 1284 and 1316, are my cases and will be set on October 29th. Remove it from, I think, the September 10th Judge Stone docket. I just don't want you to get sent down there just to hear the same thing and people try to figure it out like we're doing right now and just put in and just make a command decision. I'll take all the cases. All right. Thank you.
Write that down, quickly.
I'm sorry. Both cases, not all. Grammar police got me over here.
I think both is a subset of all,
It would all would imply more than two.
but it wouldn't necessarily.
You're going to try and talk to me about inclusive or.
He does. I think he does.
Your Honor, this is Joseph Eric Thompson, 24 CF 2424. We have a motion set for tomorrow to address additional material that we're in need of for our expert. I did speak with Ms. Basso about that before she left. That hearing will be tomorrow, and so I would just ask that he be brought back tomorrow for his hearing.
All right. We'll see you back tomorrow, Mr. Thompson, regarding that motion hearing.
I think it is. No, this one? No, it was.
Quickly see where my evening is going with all these motion hearings.
I think
I'll be
some
done
of them
before
will,
11:30 like I was last night.
I think some of them will be quick. Your Honor, this is Warren Teledano, 25 CF 392. We're going to request a continuance to the October 29th court date. I do need to set depositions.
We talked last time about some experts potentially.
Your Honor, I did retain one expert.
But depots haven't been set.
No, Your Honor.
All right, so you want October?
Yes, Your Honor.
October 29th, 9 o'clock, Mr. Taladano.
Thank you, Your Honor.
Thank you.
Mm-hmm.
Thank you.
Your Honor, this is Chaitton Troulo before the court on 24 CF 60. I have been in active negotiations with Ms. Basso. She has asked that we place this on 9/2 for plea or continue. But we believe it will be a plea.
You know, the case is from January 24, so
Yes,
I'd
Your
like to get it resolved.
Yes, Your Honor.
All right, Mr. Troulo, we'll see you next Tuesday for plea or continuance, September 2nd. Thank you, sir. Thank you. I think we're past that point.
And Your Honor, Mr. Turner, he's on my docket, and I've got a different version of yours, but if so, just so you're aware, we handled him on Monday because he had gotten out of jail. So, Your Honor, this is
That's why the
Richard.
docket was updated yesterday, right?
This is Richard Wagner. He is before the court on 23 CF 2526, 25 CF 894, 25 CF 895, 25 CF 898, 25 CF 899, 25 CF 902. And we are, once again, setting the 23 CF case for trial, and we're leaving the remaining cases on the trial docket.
Was that one set last time?
Well, they tried to set it last time.
We tried to set it last time, the state did a continuance.
The problem, Your Honor, is that I've been receiving information about additional witnesses that have information on a possible alibi that Mr. Wagner is trying to, I guess, make up. Those witnesses would be Nessa Pfizer and Casey Nelson. He's been contacting them along with the victim of the carjacking, asking them to reach out to other people to make up alibi for him and to retrieve or make up some videos that I'm not sure, obviously, what they will show because I don't have them. And he's been doing this. The last phone calls from the jail that I received from law enforcement were from this past Monday, 2 days ago. So I understand he's in a rush to go to trial because he's spoken with those witnesses to make up some sort of alibi or making them lie on his behalf, and I need to investigate that.
Disclosed?
But I found out through the jail calls.
I'm saying there hasn't been a reciprocal discovery with them?
No.
No, Your Honor.
There hasn't been a notice of alibi filed?
No, Your
No.
Honor. And, Your Honor, I would just, for the record, object to the allegations that the state is making. I have listened to, she did provide me with 2 phone calls. I have listened to one so far. And the discussion about the videos is video that he had, that he was asking to try to get access to. And as for the other, it didn't sound to me like he was asking someone to create an alibi. So I would just say, you know, we're just in a stance here, and I can understand the state's concern, but I just didn't interpret it as the same.
Can I say something?
Ask your lawyer first.
All I said was, because on the original case.
Hold on, are you about to tell me what you've said on recorded jail phone calls?
Yes, sir.
Why?
Same thing, isn't it? It's nothing incriminating.
As far as I'm concerned, if there's witnesses there hasn't been a reciprocal discovery with these witnesses and no alibi notice has been sent in. I mean, this is a 2023 case. I'm guessing that we're well past the alibi by.
And, Your Honor, it wasn't, I don't think she was alleging it for that case. I think she was alleging it for the other cases.
Well, Your Honor,
But that's not the one we're setting for trial.
Well, yes, Your
Well, I'm
Honor.
sorry, those aren't the ones we're setting for trial, the newer ones. We're setting the oldest one for trial.
Well, actually, he's not waiving his right to a speedy trial on any of his cases, Your Honor. However, his right to a speedy trial was previously waived on the 23 CF case, 23 CF 2526. He is wanting to set that one for trial as well. So he's wanting to have all cases set for trial. We talked about this last time, and the court had indicated that the speedy trial date had not run yet on the new cases, and it was left at that.
What's his speedy trial date?
On the 23 case, obviously, he hasn't been in jail since. I think he...
Oh, I understand that. I'm not worried about the 23 case. I'm worried about the, well, not worried about, I'm
Which one
asking
you're asking
about
me?
the 2025 cases.
The speedy trial, when the expiration is?
Yes.
10/24/25.
Have y'all done any sort of depositions or anything like that in those cases?
None.
And then you don't plan to, Ms. Rivers?
Your Honor, if we're able to fit in depositions on
But here's the
one of the
thing.
cases, then yes, but otherwise, no, Your Honor. He understands, and we've made it quite clear, but he does understand the consequences when you don't.
still working on an email from this morning. Go ahead.
Your Honor, I believe, and he'll correct me if I'm wrong, I believe we are going to still leave the 23 case set, because we've
Okay.
already done depositions in that case. That's 23 CF 2526. And then we are going to request continuance on the other cases. No. No continuance. Your Honor, we want to leave the one set, the 23 CF case. However, he's undecided about the other cases, and so I'm asking the court to put it on for 9/2.
All right, so we're going to set 23 CF 2526 for trial.
Yes, Your Honor.
The 2025 cases, we're going to set as what? For 9/2.
Just a continuation for today, Your Honor. I mean, he wants a speedy trial, and he wants the depositions before trial. And I've explained that I can't guarantee that.
What did you say the speedy trial date was again?
October 24th.
24th?
Yes.
Because the issue is I've got to look at the version of 3.191 that existed before July 1st, because that would have been the operative one at the time, to look into the recapture periods and everything else. Because if we're playing by the new rule, I don't think it's an issue. But I think we have to play by the old rule since the case was in place before that rule came in July 1st. So I'll try to calculate the dates, but when it comes down to it, rough estimate, if it's the 24th of October, that gets filed, and we have that recapture period the following week, and then 10 days to set the trial. Honestly, I think that puts us on November 10th anyway, which is the first week of my next trial. I'm not saying that is 100% what it is until I get the old date calculator out. But as a kind of a rough estimate, between the 5-day hearing and the 10-day recapture, I think that puts us right at literally that day. In fact, it might expire the day before, but that's a Sunday, which means it would be Monday, which would be jury selection anyway. But that's that short week. So why don't y'all think about how y'all want to handle it? But I'll put it on September 2nd.
Yes, Your Honor. I'm going to ask one question. We can do it either now or Tuesday. I need the defendant's fingerprints.
Okay.
Good. Could we get it, please?
Let me just make sure we're clear. The state's asking for him to give fingerprints, and he's consenting to that?
Yes, Your Honor.
without any sort of motion to compel or anything like that. I just want to make sure what it is.
Yes, Your Honor, it's a possession of firearm by convicted felon. We have the certified convictions, of course, and we just need his current fingerprints for the expert to do a match.
Your Honor, he is indicating that he does not wish to concede at this time and for the state to file their motion.
I'll file the motion and we can hear it on Tuesday.
That's fine. All right, we'll see y'all on Tuesday the 2nd.
Your Honor, this is Jason Walterman. He's before the court on 24 CF 1518. Last time we were here, we had indicated to the court that Dr. Zeman had tried to conduct an evaluation and that Mr. Walterman would not agree to do the evaluation. The court then spoke to Mr. Walterman about he needed to comply with Dr. Zeman and do the evaluation. I received a letter from Dr. Zeman saying that he still was refusing to do the evaluation. I did speak with Mr. Walterman. He agreed as well that he is refusing to do the evaluation. And my understanding from Dr. Zeman and Mr. Walterman, and he'll correct me if I'm wrong, is that Mr. Walterman wants to see about representing himself.
So you're concerned about competency and
Yes,
now he
Your Honor.
wants to have a Ferretta hearing.
Yes, Your Honor.
Mr. Walterman, is that right? You want to represent yourself?
Yes, sir. I believe my counsel is ineffective or incompetent to.
Okay, so what are you at? Are you asking to represent yourself or are you asking for a different lawyer?
I'm asking to represent myself pro se.
We can bring it back a different day, but I don't think we have the time for a Ferretta hearing right now. We have time tomorrow? I'm not sure.
It's going to be a big day, I think, tomorrow.
In the morning, maybe.
I don't know, we've added a few things, we've taken off a few things.
He signed the order, so it's officially on the 9th.
I was just saying, I think the Norris sentencing was moved, so that should open
Yeah, I haven't,
up a bit.
I did just sign that, didn't I? Yeah. I think we just wanted to make sure we had another date.
Yes.
Who's going to be handling that for the state?
I will be, Your Honor.
For the whole sentencing?
What's that?
For the actual sentencing?
Yes, yes, sir.
Okay, I just want to make sure I know. So I know who we're talking to when that comes up.
I won't be offended about how surprised you were. I'm just kidding, Your Honor. I'm sorry.
I just couldn't remember the date that Miss Sandler was officially done.
Yes, she's no longer with the state, Your Honor.
Okay, so it's already done. Put it on for September 2nd for purposes of the Ferretta hearing. I just don't think we have time for it tomorrow, Mr. Walterman, and since you hadn't filed anything previously, I didn't notice it, so we'll address it on September 2nd.
It's Tuesday. Your Honor, this is Jeremy Williams. He's before the court on 25 CF 702. We previously had depositions of several of the officers, however, not of the
You say
alleged.
Jeremy Williams?
Yes, Your Honor.
Okay, I'm just trying to make sure I have a lot of marks on my paper here, so.
But it was not of the victim, and the alleged victim lives in Alabama. So we were unable to prove definitively whether there was service or not, so we have to reset this matter. So we're going to ask for depositions again. This is Ms. Leon's case.
Are y'all gonna have to subpoena the out-of-state victim?
Yes.
What is the question, Your Honor?
The issue is the victim lives out of state and concerned about service. If it's an out-of-state
They
witness.
need to do what they need to do, Your Honor, I guess.
All right.
So, Your Honor, we're asking for the October 29th date. We will try to get a new deposition date with Ms. Leone and see about service for that state.
All right, Mr. Williams, October 29th. That's the end of your cases for now?
I believe that's it. I'll be working on Mr. Smedley.
Okay. Let's take about a 5-minute recess before we move to the next section.
Yes, Your Honor. Can we quickly approach real quick before you do that?
Hopefully it's processed by then. Not the one I look at, right?
Well.
All right, Mr. Williams, you ready?
Judge, this is Ronald Wayne Allen. I'm going to move to continue the case. We're still waiting on a report from the expert.
Has the evaluation been done? Just waiting on the report?
Let me look real quick. I've got a text back from Dr. Zeman, should have the report by mid-September.
He didn't seem to indicate which way it was going to go.
No, Judge.
All right. So what are you asking for, Mr. Allen, or Mr. Williams?
I'm going to ask continue it until the 27th.
29th.
29th, I'm sorry, Judge.
Mr. Allen, I'm going to put you on October 29th at 9 o'clock, but if you get that report back and talk to the state, you'll have something worked out as to how it's going to go. We can certainly put it on a sooner date.
Okay, yes, sir. Thank you.
Yes, sir.
All right, thank you.
And we'll schedule a competency hearing as soon as we get it back if it says he's incompetent.
That's what I'm saying, and if the state's willing to stipulate to the report, let's get it going faster.
Yes, sir.
Since we know it's taking a long time to resolve anything, even after we have that hearing.
Judge, this is Aaria Bell. Mr. Bell has 3 separate cases.
All right. I see 2. Am I missing one?
Maybe I just have 3 files on it. One of them may be a duplicate.
No, I'm seeing 3 in the paper docket. What am I missing here? 698, 699. All right, go ahead.
Judge, in any event, we got labs back on the trafficking, no drugs found. Right now, we've got a victim in the stalking allegation. What we're going to do is leave it on for docket day, plea or continuance. I think the state and the defense are both going to try to reach out to her and see if we can figure out what she wants to do in the case.
Was that the alleged victim in the 698 case?
Judge, I wouldn't dispute you. I'm working off of cheat sheet.
The ag stalking and
Yes, sir.
two-way device.
Yes, sir.
But FDLE came back that the trafficking charge was no drugs found?
That's correct.
All right, so September 2nd for plea or continuance. We'll see you back next Tuesday, Mr. Bell.
Yes, sir.
Hopefully I've got something kind of figured out what can go on from there.
Yes, sir. Judge, I spoke with the prosecutor earlier on Booker, and I spoke with a client. We're going to ask to approach.
Okay.
Backbone Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll.
Fight fire with fire, take one.
Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Sorry about that, Mr. Booker. While they're up here, we decided to talk about another case that's not yours.
Okay. All right, so Judge, on Mr. Booker, what we're asking to do is leave the case on the docket for Monday, plea or continuance, give Mr. Booker a chance to think over the new plea offer. I'm going to be out this weekend anyway, and I'll add him to my list.
You mean out to the jail?
Yes, sir.
Gotcha. All right, Mr. Booker, we'll see you on Tuesday. Sounds like Mr. Williams is going to come talk to you in the meantime and see if y'all can't resolve it by Tuesday.
All right, Judge, thank you.
All right,
okay.
Thank you.
Judge, I went out to see Mr. Braley last week. I just need to ask him what his decision is. Judge, I provided him, give me one moment, Judge. I went over a plea offer with him last week and left him a copy. He's advised that he wants to take it. Did you have any questions about any of the rights that you have? Is there anything on the form that you need to go over with me?
Okay. It's still the same on the.
Yeah, it's the 24 months. Okay. Let me get your signature right there. Sir, you mind if I date it for you?
Yes, sir.
Yeah, just make, I need to verify what is about, let me see, the credit and all that, let's see. I understand, but Ms. Claus said that she spoke with him and he was gonna complete the dorm program, and I had agreed to let him complete it for another 5 months.
That'll work.
I don't think he's got 5 months on it. You're like about to finish up the second to the last level, right?
It's about 5 months left.
She told me beginning of January it should be done.
Yeah.
Let's do this, Judge. Let's bring him back.
January the 4th. January the 4th.
Something like that, beginning of January, she told me.
All right, then we can't
And she
do.
said that he agreed. So he completes that and then he can get out.
Okay.
I'm sorry, the last
Yes,
thing
ma'am.
that I heard was
Sounds like a better deal to me. Thank
24
God.
months probation. Judge,
Appreciate you, ma'am.
put him on, well, what she's saying is for you to stay in jail until.
I'm good with that.
You are
Right
good
now,
with
yeah,
that.
we can get,
So how many months is that?
that's, it's a blessing. Thank y'all.
Let's say
Give me a figure you want me to put down here.
to January 4th, whatever they did. Now it's end of September. 4 months.
4 months. Okay.
Short of 4 months, right?
No, 4 months will be a little short to January 4th.
Right. That's what I mean.
I didn't know if you wanted it to expire before or after January 4th, is what you're saying.
I was good with the original 24 months probation. I'm
Yeah,
just
well,
trying
we ain't if
to
she's gonna do
accommodate
that.
everybody. All right, so what are we going to,
Can you put it until January 4th, 2024? 2026,
how do I
sorry.
phrase that? Hold in jail till January 4th, 2024? I mean, how do I make that a sentence?
You want to put 6 months and can early terminate as soon as he completes the program?
Early terminate jail.
I'm not sure. Well, we got to count the days. You want me to count it?
Well, and he's got credit for time served too, so.
Do you want to bring him back Tuesday? It's not going to make a difference.
Yeah, you wouldn't be
Because, you know-
getting out today anyway. So we need to figure out how this is going to
Exact
be
days, that's
phrased
it.
to accomplish what it is everybody's wanting to accomplish. And that just means I've got to sit down with it and she's got to sit down with it and then I'm going to have to come see you again. Okay? But we can bring it back in on Tuesday and fix it. Okay.
Sounds good to me.
All right, that's what we'll do then.
Thank you.
No,
God bless you.
let the judge do his thing.
Days until January 4th.
Then we can do that, Your Honor. Thank you.
You want me to just, well, in that case, we can do that here. 100 and, what'd you say, 132?
130 days.
130.
From Wednesday, August 27th to Sunday, January 4th.
130 days.
Just to make it clear, I'm not telling you what's going to work or not. I'm just telling you how many days that is. Because I'm not even sure what you guys are talking about yet. As far
All right,
as
so-
what's going to happen on January 4th.
Holding
Your
you,
Honor, I can explain. He's in the pod, and the pod requires a certain amount of
The
time.
ECLC
In
pod.
the ECLC. And I understand that the program is about 12 months long. He has served 2/3 almost, because there are 4 months left. So he's just has to serve the last phase of the program to graduate. That's what it is.
all right, so how about this? On the misdemeanor charges, I had adjudication of guilt, time served. How about we make that adjudication of guilt 130 days county jail, waive credit, and that will get us where we want to be, I think. Is that what you want to do?
But the,
I mean, if I had my
what about
choice
game
about
time?
it, if I had my choice about it, I'd have them drop felonies down to misdemeanors.
All right, well, but let's try to be realistic, everyone, and get towards an actual resolution. We just had quite a few cases today where I seem to have to intervene to figure out things that could have been figured out earlier.
Well, this is the first time that I'm hearing.
I understand. So if y'all want to pass it, bring it back. I just want to make some progress this afternoon, not only on Mr. Braley's case, but the rest of the docket.
Well, Judge, I've still got to go out to the jail and be there for people for tomorrow. So
You want to put them
if
on
we can-
Tuesday, since it's not going to really change anything other than instead of 130 days, it's probably going to be 125 days.
Yes, sir. So let's leave it on for Monday,
Tuesday.
or Tuesday, rather.
Monday's a holiday. All right. Mr. Braley, we'll see you back Tuesday. That's going to be September 2nd for purposes of this plea.
Thank you, Judge.
Look at that.
All right. Judge, this is Peggy Casper. Madam Prosecutor, you good with the draft order that I sent over for her furlough?
Yes.
All right, Judge, the jail has approved it, actually some weeks ago. State has approved it. I believe you already have it at your office.
I'm not sure what you're referring to other than just
Ms. Casper has a furlough for medical treatment. She's got some surgery scheduled. I just wanted to make sure that I got the state's approval on the record so the court would be able to sign it after reviewing it. If the court's good with the language, make whatever changes the court needs. I sent it over in Word format.
I haven't seen anything.
I sent it over, Judge, probably over a month ago. There was some issues with Ms. Pretty being out for a family emergency. Another fellow kind of took over, but then wanted her to look at it. Then there were issues with her insurance. But I think I've got a yes now from everybody, and your JA's been CC'd on all the emails back and forth. For our purposes, though, I'm going to move to continue it so that she can have this surgery done.
And how long is that going to be?
How long is the surgery?
No, not. How long would she have to be out on a furlough to have the surgery?
Judge, the way that the order's drafted up, and I tracked the language that the jail had, the jail will or the medical group that the jail uses will monitor her progress. She will be not allowed to leave the hospital except by further order, and they're going to notify the court and myself when she's due for discharge. They will transport her to the hospital. They will bring her back from the hospital. She's to go nowhere from the hospital, not even AMA. It'll be a violation of your conditions. And AMA means against medical advice.
Yes, sir.
All right, well, I see my assistant just forwarded me the 10-page letter that y'all sent, but I don't see the order yet. So can you make sure that you...
I will, Judge. I'll double check on it and
I'll take a
resend
look
it.
at it, but I mean, where are we at with the case? Mr. Williams, where are we at with the case?
I understand, Judge. I'm looking through my notes
I mean, the
here.
case is 16 months old.
Judge, I think, is this one where they're, because I'm sort of surprised, oh, never mind, I know. At one point, the state had offered a lower sentence. She was in ECLC. Basically, I was going to ask the state if we could put it as sale, manufacture, or deliver for 36 months or a fresh 1129 and stay in county jail, but I don't have any resolution yet. Mostly been focused on trying to get this surgery situation resolved. If I recall correctly, she failed to appear, and that's why she was brought back and wound up back in jail. Am I misremembering that?
Can I speak, sir?
Yeah.
I was in jail when I caught my FTA.
Say again?
I was incarcerated already. I caught a misdemeanor and came back. I came in on the 2nd, and my court date was on the 5th. So I was already here.
month?
Sir?
Of what month?
May, I'm sorry.
Okay.
Yes, sir.
I mean, I'm going to have to read the things. I'm not agreeing to anything until I have a
No,
chance to read it.
I understand, Judge. I don't expect you to sign the order until you've reviewed it.
Well, I don't see that I have the order yet, but if you could just double check or send another copy.
Judge,
to us.
I would have sent it to your JA, and I think it was probably what I did is I included her on the email that went out with the attachment to everybody.
The
I'll
last
find it and I'll
email she
resend it.
has is one that you sent to her, Susan Pretty, Miss Leone, John Mooring, and Mr. Sheik on August 1st, that you sent out a draft order and you were awaiting responses.
Yes, sir.
So, but, well, I can't see that the order was, not attached to the email I'm seeing now, but just.
I'll resend it,
Typically,
Judge.
I mean, even if everyone agrees, there still has to be a motion. You can't have a stipulated order without a motion. And if a motion doesn't get filed, then it usually doesn't get looked at as quickly. So it's just, I'll take a look at it, but I just.
Judge, I had filed a motion for bond, and then the jail represented in the motion what we thought Ms. Pretty was asking for, because she had contacted our office as well as the defendant. I think that's referenced in the bond motion, and what she came back with was, no, we don't want her to be released on bond. We're worried she's going to use again. What we want is a furlough.
I understand that, but I try to make sure this is understood. Just because motions get filed doesn't mean I see them. My current caseload is over 1,400. I can't read everything that gets filed. If it was a bond hearing, it would have been, I don't typically look at bond hearings unless they're number one, agreed upon, or two, set for hearing. But I don't want to spend 10 minutes on every case trying to figure it out. If you need me to read it, I'll go read it, but we're not going to do it while everyone's waiting.
That's fine, Judge. That's why I was asking for a continuance, is so that we could.
All right, so what date are you asking for?
The next docket date. Her surgery should take place sometime this upcoming month.
We want October 29th, but is she going to be back in time for that?
Judge, I will be very surprised if she's not. Obviously, I can't render a medical opinion, but I would assume that she would be back by that date.
Well, but that's the thing, that Mr. Rollins, someone has to give a medical opinion, so I know what I'm actually signing off on. If she's going to be out for a week or 6 months, I mean, I don't want to talk about what's in the letter that I've seen, because I don't want to talk about her medical issues, not only in a courtroom, but with a camera rolling.
Yes, sir.
But I need to know those things. Otherwise, I can't really make an educated decision. But I'll take a look at what's been sent over, and I'll make a decision on it.
Yes, sir.
All right. October 29th.
Thank you, Judge. Judge, at this point, Mr. Cleary actually has 3 cases. There's the original one that I was appointed on, and then there's 2 that I believe are set for arraignment tomorrow. They originally had Mr. Maddox assigned to them. They've been reassigned to me, and when I looked just a few minutes ago, I'd filed notices of appearance on both of those. So what I'd like to do is go ahead and enter a plea of not guilty and arraign him on the ones that are set for tomorrow. Do we have information on both of them? Madam
It should
Clerk.
be my cases, because I have the first one. I'll check.
There was one that I was looking at, and I remember thinking that they didn't have any information on it. And the 2 case numbers are 1331 and 1332.
They've all been filed.
Okay. In that case, let's go ahead and arraign him on those and set him off for whatever the...
Ray, can you see if there's one on 1332? I can see one on 1331. I don't see one on 1332. Hold on a second. What case numbers do you have?
All right, I've got 2025-601 is the one that I originally had.
Yes.
And then he picked up two more cases, 25-CF-00-1331 and 1332 is what I have.
I think we discussed this earlier. Sometimes it just generates another consecutive case number, and it's the same case. And I just want to make sure we're not talking about two case numbers that are really just one case again.
It appears from my records, Your Honor, it should be two different charges. They're not the same. They're not duplicative.
Okay.
Yeah.
Do y'all show an information filed on 1332?
I show that I prepared it in my system. Would the court like me to print it and just now file it?
If it's been filed, I just, got to be filed, and then he has to get a copy of it. I mean, I'm just not sure why we're not handling this tomorrow, since that's when it's actually
Let's just
set.
do that, pass this one for tomorrow.
So what are we doing with today's case?
Well, Judge, I'm good with passing all of them until tomorrow and then just setting this one with those.
All right. So we're moving 601 to tomorrow at 1:30.
Thank you, Judge.
All right. I'd like to get moving a little quicker on
Not
this.
right now, no, sir.
You and I before tomorrow.
I will try, but it's probably kind of doubtful. I'm going to be in court here until late. I'll be out the jail seeing some other folks. I'd already seen
So
you.
I still don't get to see you at
No,
all?
you did get to see me. I was out to see you
No,
a
sir.
couple of weeks ago. Yes, sir.
Not on this arson that I didn't do. My home burnt. I lost everything.
Sir, actually, the arson case is the one that I've had for months.
Sir, I've tried. I lost
Sir,
everything.
sir.
Yes, sir.
Yeah, y'all can talk at the jail, but this is not the place, especially to have a heated discussion.
All right, Judge, this is Gary Kao, Judge. We've got a opinion back from Dr. Zeman, and I filed a notice of intent to rely on the insanity defense. I don't know if the state's wanting to have their own expert. I filed that on 8/20. And that's how our last meeting went.
I understand, Mr. Williams. It's just every case, there's a big delay.
Yes, sir.
It's failure to sex offender. Gary Kao. He's got a VOP and a new law. Filed on it. I mean, someone filed on it. I don't know. I did. He's got me, but because he was enough. He's got can we continue to Tuesday? Was on an inactive docket and the case was reassigned.
Mr. Williams?
Judge, I don't have any objection to that.
All right. September 2nd, no subpoenas.
Okay, Mr. Kay. Judge, sorry, I thought Mr. Gainey was next. Judge, this is Mr. Harrison. The case is somewhat old. I don't know that it's going to be able to be worked out, though. I've been trying to get him into a program. We've got one accepting him, but just to move things along, let's set it for docket day. Clear continuance, and, oh, wait, no, when you and I talked, we were talking about going ahead and continuing it. You need to take the ladies' depot.
Yes.
All right. Judge, there's one depot that we need to take, or that I'm going to take, so I'll move to continue it one more time.
That depot set yet?
No, Judge, it's not. We had the discussion about it this morning. I've been suing for peace on it, and we've got him in a program that will take him, and another fellow that keeps showing up trying to get him in his program. And unfortunately, it looks like we're going to need to look further into it.
October 29th.
Thank you, Judge. We're skipping. Judge, this is Joseph Horn. Let's set it for docket day, plea or trial.
It is ready, and the offer will be revoked on Tuesday if he doesn't take it, because we're going to go forward on both drugs, the fentanyl and the...
I'll come out and I'll talk to you about it. What they're saying is, well, we've gone over their offer. They're going to revoke that on Tuesday. But you and I'll talk about it this weekend, okay?
Okay.
Okay.
All right. September 2nd, plea trial.
Done.
Okay, yeah. I'm sorry, sir, what's your name?
Maurice Horn.
Judge, I don't believe Mr. Horn is mine.
I've got you listed for him.
Yeah, I don't have you in my notes for today. Hang on, Judge. I was working off the, okay, yeah, I found you. Judge, it looks like we got discovery on his case on August 12th. I'm going to move to continue it.
All right. October 29th will be your next court date, Mr. Horn.
Okay. Sir, what's your name?
Johnson.
Sorry, Judge. What's your first name again, sir?
Tanner.
Tanner, okay.
Yes, sir.
Judge, this is one where we got discovery on the 14th. I'm going to move to continue it. I did talk with Dana about you, and she's going to work with you. Let me look real quick.
All right, anything else, Mr. Williams? All right, 10:29,
I'll bring you
9
back
o'clock.
early, but right now, you're scoring state prison. Judge, this is Tyler Blake Jones. Mr. Jones is willing to accept the state's offer. He's got a hold in Okeechobee. It's going to be a county jail offer. Well, let me make sure that I'm right on the time. The jail. I'll pass it till Monday for plea or continuance.
September 2nd for plea or continuance.
How are you doing?
Hey, how you doing, Dominic? Spread out over several copies.
Oh, that was the
No. Judge, I'm going to move to continue Mr. Lee's case. It looks like it's the first time up. I'll make a note.
October 29th.
Thank you, Judge.
Thank you, sir.
Okay. What's your name, sir?
Kwame.
Kwame.
Lee. Lee.
Here we go. Judge, this is going to be first time up. I'll move to continue it. Looks like discovery was received today.
All right, Mr. Lee, October 29th.
I'll go through, see what the offer is, and if it's something that would get you out, I'll come out and we'll get you on early. Judge, this is Max Moss. He's got
Michael Manning. Or should be, right? It's Manning.
Judge, this is another one. We got discovery, and there's a BOP dated 8/14. I'm going to move to continue it. I think this was one of the ones that we had. No, that was Moss. Okay.
All right, October 29th.
Thank you, sir. That's it? That's it.
When do I come back?
October 29th. Sir, what's your name?
McDonald.
Andrew McDonald.
You're Eric?
Andrew Eric.
Andrew Eric? Okay. Judge, he filed a request for a Nelson hearing, and you set it for to be heard this afternoon. I think you're Michael's son?
Robert Michael.
Robert Michael, uh-huh. Yeah. Is that the basis of the conflict? Because we'd withdrawn before because we were representing your dad, but we don't represent him anymore.
No, sir, you don't represent him. You represent yourself?
Yeah.
Raise your right hand, sir. Do you swear or affirm the testimony about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Andrew Eric McDonald, 10/11/1984, sir.
Why does your Nelson inquiry, it says State of Florida versus Eric A. McDonald? I have. Am I looking at the wrong one? Same case number.
Andrew Eric McDonald is my name, sir.
It says Eric A. McDonald. And it seems to be the same handwriting that I get on your father's pleadings as well. So I'm just trying to figure out what the
My
problem.
brother, actually, sir. Yes,
Who?
sir.
Your brother? I thought you said father.
He said father.
Okay. Well, that's what I heard. Okay. So,
My brother,
I just want to know why your name is wrong on your Nelson hearing request.
I may have wrote it wrong.
You may have written your own name wrong, or did someone else write this for you?
I use the way
Did someone else write this for you?
My brother's helped me out with this, yes, sir.
Okay.
he fired Mr. Williams from a conflict that he had with him, started representing himself.
So what are you asking here?
Mr. Williams has represented me in the past with a case similar to the one that I have today, going on today, where I had two attorneys. One back then, I had Mr. Notes representing me in a felony case. He represented me in another felony case. And I asked Mr. Williams to advocate to the state for me where I wanted treatment. I was looking to.
What is your concern in these cases that are currently in front of me?
That Mr. Williams won't represent me to his full capacity. I feel like he has a total lack of regard for what's in my best interest.
Well, tell me about it.
Well, that's what I'm trying to explain. I was trying to explain, sir, in the past.
Well, you're talking about previous cases with other lawyers. I'd like to, if you just kind of focus on. Can you move that monitor out of the way as well? That makes it a little easier.
I
Sorry about
apologize,
that,
sir.
No, it's okay.
I know the focus is on this case, should be on this case, but prior to this case, I didn't feel like he represented me to his full capacity then, and I don't feel like he will currently.
Well, what has he done in this case that's been a problem?
I requested to his office for the discovery of my case. I'd like to participate in the ongoing discovery of my case.
Do you not have copies of your own discovery?
No, sir.
Mr. Williams?
Judge, I don't know why that would not have happened. We routinely send copies upon request. I can check.
Which case don't you have discovery on, Mr. McDonald?
I have discovery.
I'm asking Mr. McDonald, Mr. Williams. Mr. McDonald, what cases don't you have it on?
I actually have no paperwork on, not even an arrest report on myself, because I came from the hospital, and when I was booked in the jail, they didn't give me no paperwork or anything. I had no paperwork as, concerning my arrest, nor do I have a discovery. Over 30 days ago, I sent a request to the Public Defender's Office.
All right, when was discovery sent over, Mr. Sheik?
For which case?
The 1192. That's the new law violation. The others are VOPs, right?
Yes, Your Honor. The new one, I believe it was 8/15 or 8/14, somewhere. I know it was officially filed on the 15th. And then there was an amended discovery sent on the 20th, Your Honor.
Okay, so discovery was just sent in the past week or so. And so when you filed your claim on the 18th, discovery was only filed a couple of days before that, so he didn't have it to give it to you.
Yes, sir. I understand.
Do you want to give him time to give it to you? And it looks like something was filed subsequent to your inquiry as well. I can't just, you don't think he's going to do a good job. You got to tell me what has happened that you're concerned about.
In this case, I can't say that there's anything happened. I can only talk about I've had dealings with Mr. Williams in the past, and they wasn't good, and I don't want to be his representation to be forced on me. I don't feel like he represented me in full capacity in my prior history with him.
Yes, go ahead. Go ahead.
I don't know if that's sufficient enough to argue because it's not in this case, but.
Well, but you haven't given me any specifics as to what he's done. I've read your inquiry, where you're just talking about in the past, and then that you allege some sort of conflict of interest specifically with other members of the accused's family.
That would be with my brother.
What does that have to do with you? Well, my concern is someone else wrote this motion for you, and you don't even know what's included in it.
I know that in that motion that there's.
I'm sorry, not motion, Nelson inquiry. Go on.
Nelson inquiry, I know I addressed the issue with my brother and the conflict that they had where my brother got rid of Mr. Williams and started representing himself. And I'll address the issues of the past. I didn't make a copy of for myself, sir. I have it here to look at.
But your complaints, what are your complaints other than he and your brother didn't get along and he got off his case?
Currently, the only thing
And again, I'll point out, because I've seen numerous filings by your brother,
Yes,
this
sir.
appears to be his writing. And my concern at this point is your brother filing things on your behalf, and do you even know about it, number one?
I do
Or
know
two,
about
is he basically acting as your lawyer?
He is not acting as I do not want my brother to represent me, sir.
Well, I understand.
You know, I want representation. Like I say, in the past, when I had Mr. Notes, I also had I had Mr. Williams, I had Mr. Notes on another case at the same time, and when we came up here and finalized that deal with the state, there was a global resolution. I was before another judge.
Okay.
And I felt Mr. Williams was totally lost in what was going on. He wouldn't advocate to the state. I was trying to get treatment.
But do you have the same complaint about Mr. Nopes then?
No, sir. He finalized that deal for me, and Mr. Williams stood here at the podium with Mr. Notes, and I felt like he was totally lost of what was going on, just agreeing with him.
But you got what you wanted. Mr. McDonald, is it safe that you got what you wanted?
Did I get what I wanted in that deal? Yes, sir.
Okay. All right. Well, unless there's something else, I'm going to deny your Nelson inquiry.
Yes, sir.
All right. Nelson inquiry is denied. What do you guys want to do with the case?
Judge, I'll move to continue the case. It's the first time up, and we just got discovery.
All right. I'm sure he's going to come talk to you about it, but he just got discovery himself in the past few days or last week while he's preparing for his other numbers of cases as well. So he'll come talk to you about it. If you've got future concerns, you can certainly bring it up through a similar inquiry. But I've got to hear something more than in the past, my brother had an issue with him, or in the past, even though I got what I wanted, I felt that he didn't do it right. So there has to be something more concrete, Mr. McDonald.
Sir, in the past,
I'm not going to go through it any further at this point.
Yes, sir.
All right. October 29th.
Your Honor, if I may?
Yes.
Apologize.
Hold on, Mr. McDonald.
So based off of some of the victim's statements, she has been contacted by the defendant as well as other people on behalf of the defendant, and I just wanted to put it on record that the state will be investigating that, whether or not we need to add an additional charge.
All right. So, Mr. McDonald, what the state's advising you is they have reason to believe that you or someone on your behalf is reaching out to the alleged victim in this case would be a violation of the conditions that were put on you at your first appearance. I know we call them bond conditions sometimes, but once the judge orders them at first appearance, even if you don't bond out, they're still in place. I'm not saying you've done anything wrong. I have no idea. But obviously, you've been ordered not to have contact with this alleged victim, right?
I don't recall being told by the judge at first appearance that I couldn't contact the victim. If I'm wrong, would you please advise me of the stipulations so that I don't violate anything? I know my mother's been...
Hold on. Mr. Sheik, I'm looking at the bond paperwork now that you brought it up.
Yeah.
And I don't see anything checked on there. I mean, he was given no bond across the board at first appearance, but I don't see anything there where there are conditions. But am I missing something?
No, I apologize, Your Honor. I didn't specifically look because typically in a case like this that...
All right, well, I don't see anything there. So you're correct, Mr. McDonald, that the judge at first appearance doesn't appear to have, I mean, I can't tell you what was said, but I can look at the paperwork and none of the boxes for no contact, don't go back to the house, none of those are checked. So you don't have those bond conditions that I can see, and I can't just go changing those without prior motion.
Yes, Your Honor, the state will be filing a motion.
Okay.
So at this time, I don't have no stipulations. I could talk to her if I wanted to. If she answered the phone, I could call her.
I'm not going to answer that question. I'm telling you, I don't see any restrictions that were put on you at first appearance, because I don't want it to sound like I've told you can talk to her. The next thing you know, they think you're tampering with her in some way, and well, the judge told me I could. I'm telling you, the first appearance judge didn't put any restrictions on you, and I'm telling you, no motion's been brought to my attention or filed and set for hearing that would say, Judge, put those conditions in place. All right. Thank you, Mr. McDonald. October 29th. Mr. Williams, this is Mr. McTier, right?
Yes, Judge.
25 CF 1223. This is our first pretrial conference.
I'll move to continue the case, Judge.
All right. Have you received discovery yet? All right. Have you been able to talk to Mr. McTier about it yet?
No, Judge, I have not. Issue with regard to discussion with Mr. McTier. We attempted to get some expert assistance on this, but that has not taken place. Let me check. And the state's offer in this case is not something Mr. McTier is going to take at his first court date. It's 20 years state prison.
All right. Anything else?
Not at this time, Judge. I may be filing a motion with regard to that. I'm going to reevaluate, as I do every time I see clients where that's an issue.
All right. October 29th.
Thank you, sir. All right, Mr. McTier. Judge, we're going to leave this case on for docket day 9/2. The state and I are going to try to reach out to the victim and discuss with the victim where they want to go with this.
And what if it doesn't resolve on that date?
I'm going to say plea or continuance. I don't think the case is that old. Well, it is old, but
It's a year old tomorrow.
I think there was a time when he was not. I think he failed to appear at one point, Judge, and was at large.
It was about half the time he was out on Acapia status. All right, September 2nd, plea or continue.
Thank you, sir. All right.
Thank you, Mr. Moore.
Judge, Mr. Moss is scheduled for a VOP tomorrow. If you'll recall, we originally thought we had an agreement when we came in for arraignment, but there was a VOP that had just been filed. Let's, if we can, deal with this tomorrow, and perhaps the state and I can reach an agreement on it.
That VOP came after about him being on probation for like 2 weeks.
Yes, sir.
All right, we'll readdress it tomorrow with his VOP. We'll see you tomorrow, Mr. Moss.
Okay.
What time is he set on this other case?
I think
9
Mr.
o'clock.
Moss is on for 9.
9 o'clock. I already pulled it up. I just didn't look down at it.
Judge, this is Aiden Mungia. I'm probably mispronouncing that.
Mungia? Okay.
And Judge, what I've got is that I think this is the first time up or close to it.
You have discovery?
I believe I do, Judge. There were a few that we had some issues on. 822 and 819. We got our initial 819, and then the state amended 822. So I'm going to move for a continuance, Judge.
All right, October 29th.
All right.
Come out and talk to you.
Excuse me? Hang on.
What's the offer?
Do we have a probation offer on him? That's right. I think we do. I just haven't had time to.
Offer from the state is an adjudication of guilt, court costs 50 hours of community service, 2 years probation, and no contact with the victim.
You want to do that?
Yes, sir.
Okay.
Yes, sir.
Judge, they didn't bring him down until just a few minutes ago. I did speak with him, but prior to that, all right, so does the court want me to leave it on for tomorrow and draft it up for him, or try to write it up right now?
Do you have a form it can be written up? I think Ms. Rivers has at least one or two to figure.
I've got one for you if you need it.
And it would be a guideline, Your Honor.
Yes, let's bring back Mr. Mungia. He's going to talk to you about that offer, have you look over the paperwork, and we'll bring you back later today.
All right.
Hey, there today? Okay,
Yes.
cool, thank you.
Oh, Dykes, we're going to continue
Yeah.
till 10:29, but that's the last continuance, and put that, I don't know, all
Okay.
caps, bold, however you want to do it.
Okay. Glenn, it's just like we went over, okay? The pre-trial intervention agreement. Okay, I'm gonna date it for you, okay? All right. Your Honor, do you need me to approach this to take a look at it, or do you want me to give it to probation?
It's a pretrial intervention.
Pre-trial intervention agreement without a plea, Your
Without
Honor.
a plea, let me just take a quick look.
Sir.
All right, Ms. Glenn, did you understand the agreement that you signed?
Yes, sir, I understood.
All right. Are there any special conditions?
She needs to get a mental health evaluation and any recommended treatment, Your Honor. In the event that she completes all of that and it's done within a year, the state agrees to early terminate the agreement.
What I'm going to do is I'm going to put it on October 27th for purpose of status. Once it's filed, after DOC deals with it, once we get it in the court file, we'll cancel the court hearing. But is there anything else holding her?
No, Your Honor.
All right, so you should be released today. It might be late.
Okay, thank you.
And
Thank you, sir.
Actually, it might be tomorrow. I just can't say by the time the paperwork gets processed and sent over to the jail, it may be too late for today, but we're trying.
Thank you, sir,
thank you.
Judge.
All right.
Not sure if you can do it any faster than that, but. But she's accepted DTI and can be released. But that date is just status once y'all get the signed file, or signed copy of the file.
pleaded a lesser included offense as a misdemeanor.
For 2 years probation?
Yes, sir.
And then that goes, or what is the,
What motion hearing is what Byron Williams? Oh, to be relieved. Oh, that's what it is. Yeah. Still ongoing.
Well, I hadn't set a date to work.
Oh.
Yes.
Okay. My, because we just got this docket like an hour ago.
All right, that's good. Thank
I'm
you.
going to it now.
No, that's it. That's
so I'm
just
getting
that
out
one.
today then?
Yes. All right, Matt Rich.
Yes. So is he pleading to 2 lesser includeds?
Yes, Your Honor. 2 lesser included misdemeanor batteries.
All right, Mr. Air, raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your name and date of birth, please?
William Ayer, born July 21st, 1979.
All right, Mr. Air, you're here in 25 CF 1110 and 25 CF 1334. Both are a single count of felony battery, which is a 3rd-degree felony punishable up to 5 years in state prison. Do you understand that?
Yeah, I thought went down to a misdemeanor.
I'm advising you what you're currently charged with.
Okay, so
All
if
right, you
I
can
mess
put
up again, I got you.
You can put your hand down.
All right.
I've been handed a plea and sentencing agreement that calls for you to plead to a lesser included offense of misdemeanor battery on each of those counts. So it'd be 2 misdemeanors. Do you understand that? You'd be given 11 months, 29 days consecutive on each case, so basically 2 years probation. Do you understand that?
I complete 2 years, gotcha.
All right, complete anger management can be done online. 622 in court costs. Shouldn't there be 2 court costs? And shouldn't they be a
Every case is
misdemeanor?
yes, in each case, Your Honor.
What's court costs on a misdemeanor battery? 622? So it's 622 court costs each, so times 2.
That's 12 something.
1244. $100 cost of defense.
Each case.
Well.
That's 200.
Well, 100 and.
No, it should be 50, 50, and 50, right? Because they're misdemeanors.
Okay, yes.
So what does that average?
150 court cost of defense, adjudication of guilt, and waive cost of supervision. Is that what you want to do today, Mr. Ayer?
What's that mean?
It means you don't have to pay probation fees.
It's on the document that you've signed, Mr. Ayer.
Okay. So
You
I'm just paying
understand?
court fees. and
Say
court
again?
fees. Okay, yeah, that's fine.
You understand it?
Yeah.
Okay. Have you gone over this plea agreement with your lawyer?
Yeah, yes, sir.
And did you understand and sign the agreement?
Yeah.
Excuse
Yes,
me?
sir. Yes, sir.
All right, just, you got to speak up.
Yes, sir.
All right. And are you satisfied with your lawyer's advice and representation?
I'm fine. I'm ready to go.
All right, Mr. Ayer, all you have to do is answer what I'm asking you. Are you satisfied with your attorney's advice and representation?
Yes, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
Sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that by entering a plea that there won't be a trial of any kind and you're giving up your trial rights, which are listed on page 2 of that agreement that you signed?
Yes, sir.
And do you understand that you're waiving all potential defenses that you may have?
Sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
And what is your plea to the 2 separate counts of misdemeanor battery?
No contest.
All right, I'm going to accept your no contest plea as freely, voluntarily, knowingly given. That's adjudication of guilt to misdemeanor battery 784.031A1. On each count, it's going to be 11 months, 29 days, consecutive probation. Anger management course can be completed online. $622 court cost per case for $1244 in court costs. Each case will be a $50 cost of defense plus a $50 application fee. That's a total of $150 cost of defense, and waive cost of supervision due to the fact that you're indigent and represented by the public defender's office.
Your Honor, I'm sorry, I think might have completely missed it. No contact with the victims.
No contact with the victims. You understand you can't have any contact with the people?
I don't want to contact them. They're going to.
Do you understand that you can't
Yes,
have
sir.
contact with them, and if you do, you could be arrested?
Sir.
All right. I'm going to just. All right, I need you to talk to probation behind you, Mr. Ayer. Then you'll need to be fingerprinted, and you have 30 days to appeal the judgment and sentence of the court. Thank you.
One question.
All right, who else do we have? All right, Chad James.
Yes, Chad James.
All
24
right.
CF 2922, Your Honor.
All right, what have we figured out with Mr. James?
We are going to resolve his case today, Your Honor. The felony case with credit for time served, to withhold adjudication, $615 in court costs, $150 cost of defense. Mr. Sheik and I have gone ahead and written up a separate plea agreement for his misdemeanor cases. We'll file that today for him, Your Honor.
Okay, so
But that'll be dealt with in county court.
All right, so Judge Ward could potentially deal with that as early
Yes.
as tomorrow.
Yes, Your Honor.
All right.
Court tomorrow. We're going to file your other plea agreement for you in county court and expedite it, date it for me.
Mr. James, you understand what the concern was, right? I just didn't want you
Yes.
to end up on DOC probation where they wouldn't let you go back to Mississippi?
Yes, sir.
Yes, Your
Okay.
Honor.
There's going to be misdemeanor probation for that.
We'll file that one for you.
Did y'all have a chance to speak with anyone from JCS or anything like that?
No, Your Honor, but like I said, in my experience dealing with GCS, they've not had an issue supervising anybody out of state as long as they have a driver's license with their address on it, which Mr. James does. Matt Birch.
Yes. You hadn't asked. All right, Mr. James, can you raise your right hand? I think I swore you in earlier, but just to make sure, do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, I know we went through a lot of this, but it's somewhat different now, so I'd rather just do it from scratch or from the beginning here. Can you state your name and date of birth, please?
Chad James, December 18th, 1982.
And Mr. James, you're here in 24 CF 2922, charged with possession of a controlled substance, third-degree felony. Do you understand that?
Yes, sir.
All right, I've been handed a plea and sentencing agreement that calls for you to plead no contest, to be a withhold of adjudication, which means no conviction, time served, $615 court costs, and $150 cost of defense. Is that what you want to do today?
Yes, sir.
Did you read all this with your attorney?
Yes, sir.
Did you understand it?
Yes, sir.
Satisfied with your attorney's advice and representation?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Anybody force, pressure, or threaten you in order to get you to plea?
No, sir.
Anyone promise you anything in return for your plea? All right. Any questions before we finish up?
No, sir.
All right. Do you understand there's not going to be a trial and you're giving up your trial rights, which are on page 1 or page 2 of that document you signed?
Yes, sir.
And you understand you're waiving all potential defenses?
Yes, sir.
All right. And what is your plea to the possession of controlled substance?
No contest.
I'm going to accept your no contest plea. It's freely, voluntarily, knowingly given. Credit for time served, withhold adjudication, $615 court costs, $150 cost of defense. I'm going to give you 90 days from the date you get released to either pay those costs or set up a payment plan for them.
Yes, sir.
All right. Any other questions, Mr.
No, sir.
James?
Thank
All
you.
right. Then I don't think I need anything else because it's a withhold.
Thank you, sir.
All right, you have 30 days to appeal. It is a guideline sentence.
Your Honor, this is Mr. Strafac before the court in 25 CF 444, or 440. Your Honor, I've talked to the state about this. They do want an opportunity to reach out to the victim, and we will set this for a competency hearing on September 2nd.
Competency hearing on the 2nd?
Yes, Your Honor.
Yes, and
You've got the report.
we've got the report. We will stipulate to the one that the defense has already, Your Honor.
Okay, has it been filed?
It may have been last time, Your Honor, but I don't think so.
I couldn't get it on.
But y'all haven't given me a copy, right?
I may have last time, but no, not for the, no, because I don't believe a decision was made on his competency as a result of the state initially requesting a second report.
Okay, well, so are you stipulating on the one report?
Yes, Your Honor.
Okay.
I would provide the court a copy today, Your Honor, but this one's highlighted. I don't have a suitable copy for the court. I'll bring one on September 2nd.
All right, September 2nd for the competency evaluation.
Thank you, Your
See
Honor.
you back on Tuesday, Mr. Strafac. What does it start with?
I believe that was all the cases I had to recall.
Hold on, we may have Enzenbacher?
Enzenbacher? Oh, good. He's on the docket today. I didn't see him on the docket, and I don't think he was on the transport list, but he
Let's not all
should have
talk
been.
at once.
He should have been.
He's not here. He's on the docket, though. Well, he's showing up on my screen. What were you trying to get done with him, Mr.?
So Mr. Enzenbacher, Your Honor, came back from the Florida State Hospital. They recommended he be found competent to proceed. I don't believe we've had an actual competency hearing on that. And in any case, I'm going to have another evaluation based on my conversations with him, Your Honor. I think it would be appropriate here.
Is he in the jail?
He is, Your Honor. He's been transported.
Do we want to see him next week, or?
Yes, Your Honor, that would be fine. If you want to put him on.
It's not that what I want. I'm asking if that's what you want to do, but.
Yeah, I think that would be appropriate, Your Honor, just so that he can be before the court and we make sure there are no other issues that come up.
That's fine.
All right, September 2nd.
Oh, he doesn't care? He wants you to go over to Santa Rosa? Okay, that's fine, okay. Your Honor, I believe we've reached an agreement on this. Now, if I can just find the plea agreement. Here we go. We're going to mark that out, the credit for time served. So that allows you to do it. Completely different. Your Honor, we've reached an agreement for May approach. Because he's that committed to the program.
Okay. I think the other thing that at least I think I brought up was 1129 is a condition of 1129 probation, but what about jail? Well, you get gain time if your jail is pursuant to probation.
It would be a condition of probation, the jail, the 1120.
Early termination upon completion?
Completion of what?
1129, jail sentence?
Well,
There's
it would have to
nothing
be
in here
completion
about-
of the ECLC program.
There's nothing
right?
in here about ECLC.
You want it just listed in there, the ECLC? Kind of the whole point of doing the probation.
Well, I understand. If you could Write it back in. I just don't want to keep writing terms into plea agreements.
Or we could just drop it.
Mary, can we do this on 9-2? Let me just rewrite it. To write it.
That's fine, that's fine.
Okay.
And then it will be typed out on top of that.
All right, so I'll be able to read it. All right, so Mr. Peacock, we'll bring you back on Tuesday, September 2nd. It's not going to really change anything.
Yes, sir.
But just to make sure it's all clear and everyone's got
Yes, sir.
their idea on what it's supposed to be.
Thank you.
All right, thank you, Mr. Peacock. Let me give you that score sheet back, just so it doesn't get lost.
You need to ask Jason McKinney, because they've been doing this language for the ECLC program in the South End, and he's got a nice way to put it.
Mr. Smedley?
Yes, it is, Your Honor. A moment to sign the plea agreement. We have gone over it. To sign it right there.
Yes, please. So it's 18 months DOC followed by 18 months probation.
Correct.
All right, Mr. Smedley, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your name and date of birth, please?
Avon Smedley, February 3rd, 2004.
All right. Mr. Smedley, you're here on 2 violations of probation. Oh, I'm sorry. 1 case of violation of probation, which is 22 CF 2688, as well as a new case of 25 CF 502, which you're charged with possession of a weapon by a convicted felon, second-degree felony punishable up to 15 years in state prison, as well as count 2, possession of marijuana misdemeanor, punishable up to a year in county jail. Do y'all understand what you're currently charged with? Yes. All right. I've been handed a plea and sentencing agreement that calls for the VOP, that you'd admit your violation of probation, they would revoke your probation, you'd serve 18 months Department of Corrections with credit for time served, followed by a new 18 months probation with a $100 cost of prosecution, $100 PD fee, and $50 application fee. And then in 25 CF 502 is the new case. On count 1, the possession of a weapon, 18 months DOC with credit for time served, followed by 18 months probation. Count 2 is the misdemeanor marijuana. It'd be just 11 months, 29 days jail, concurrent with everything else. So it's basically no probation on that one. And 415 court costs, $100 cost of prosecution, $100 PD fee, waive cost of supervision on the probation, and all jail and probation sentences are to be concurrent. Is that your understanding? All right, is that what you want to do today? Did you go over this plea and sentencing agreement with your lawyer? Did you understand it? And did you sign it?
Yes.
Yes. And are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter these pleas? Has anyone promised you anything in return for your plea? All right, in the violation of probation, do you understand by admitting there's not going to be a hearing where the state would have to prove that you had violated your probation?
Yes, sir.
And do you understand that in the new case, if you enter a plea, you're giving up your right to a trial and all your trial rights, which are listed on page 2 of that agreement you signed? And do you understand you're waiving any potential defenses you may have in all of those counts? All right, and do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right, and on the violations of probation in 22 CF 2688, what is your plea? Are you admitting or denying? All right, and in 25 CF 502, what is your plea to the possession of a weapon by a convicted felon and possession of marijuana?
No contest.
All right, I'm going to accept your no contest plea as well as your admissions to the violation of probation as freely, voluntarily, knowingly given. And 22 CF 2688, revoke your current probation, 18 months DOC with credit for time served, followed by 18 months of new probation, $100 cost of prosecution, $100 PD fee, and $50 application fee. And 25 CF 502, count 1 is going to be 18 months DOC with credit for time served, followed by 18 months probation. Count 2, 11 months, 29 days in county jail, concurrent to all of your other cases and counts. All DOC, jail, and probation sentence are to be concurrent, which means that they run at the same time. 415 court costs, $100 cost of prosecution, and $100 PD fee, waive cost of supervision. This is a guideline sentence. I see that he scored 16.35 months. This is 18 months. Anything that I've missed?
No, Your Honor.
All right, thank you. All right, so Mr. Smedley, you're going to turn around and talk to probation quickly, then you're going to be fingerprinted up here, and then you have 30 days to appeal the judgment and sentence of the court. Yes, otherwise it's time served.
Oh, just making it. Yeah, of course.
Thank you, sir. Just let it fall right on there. All right, sir, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right, can you state your name and date of birth, please?
That's Alan Mungia, 6/10/1974.
All right, and you are here in 25 CF 993. I'm just going to write that on the plea form. Where you're charged with grand theft auto, third-degree felony, punishable up to 5 years in state prison, and possession of drug paraphernalia. It's a misdemeanor, punishable by up to a year in jail. Do you understand that?
Yes, sir.
All right. I got a plea and sentencing agreement. Calls for you to plead no contest to both counts. Adjudication of guilt, 2 years of probation, 515 court costs, $150 PD fee, 50 hours community service, and reserve restitution for a period of 90 days. So once they either y'all have an agreement on the amount of restitution, or we can have a hearing on that.
Okay.
It'll be figured out over the next 90 days.
Okay.
All right. Is that what you want to do today?
Yes, sir.
Did you go over this plea and sentencing agreement with your lawyer?
Yes.
Did you understand and sign it?
Yes, sir, I did.
And are you satisfied with your attorney's advice and representation?
Yes, I'm satisfied.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for this plea?
No.
You understand by entering the plea, there won't be a trial of any kind, and you're giving up your trial rights, which are on page 2 of that agreement you signed.
Yes, I agree.
All right. Do you understand you're waiving all potential defenses that you may have?
Yes. Yes,
and do you
sir.
understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes.
All right. And what is your plea to the grand theft auto and the possession of paraphernalia?
Guilty.
No contest.
It
Sorry.
says no contest on the form. I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty on both counts. 2 years probation, $515 court costs, $150 PD fee, 50 hours of community service, reserve restitution for a period of 90 days, waive cost of supervision due to the fact that you've been found to be indigent and are represented by the Public Defender's Office. This is a guideline sentence. You scored 22.2 points. So I just need you to go talk to probation quickly, Mr. Mungia, then be fingerprinted, and then you have 30 days to appeal.
Okay, thank you. Thank you.
Good luck, sir.
Miss Rivers leave.